All right, now let's see if we're going to have actual live chat. Wouldn't that be great to have actual live chat? Let's see if we have live chat. Well, all right. So I guess I'm not going to F around too long on this. So this is the third amended complaint. And, oh, we have live chat. Yay. Hello, people. I didn't think you'd gone kid-friendly. Well, I'm not kid... Oh, it must have set it to this stream is made for kids or something. Yeah. Oops. My bad. I'm dumb. So the attorney who wrote this is the same attorney who wrote Pulliam's complaint, and this attorney loves to pad the fuck out of the complaint and throw in pictures and just like it's a class project and stuff. Like what does this picture add? And what is all the background on Black Label Cop Watch Mexican Videa? What all does it add? Which dunce cap is Salvaggio? Salvaggio was the chief of police for Leon Valley. That's what dunce cap Salvaggio was. All right, so the actual on page 12 is where the actual meat of the complaint starts, where he actually starts making the allegations. This is the again background. The Leon Valley, their city building had offices for the city workers, it had the police department in it, and it had the city court in it. These section 30.06 and 30.07 signs, they basically restricted your ability to carry a firearm in a courthouse. And because the Leon Valley building had a courtroom in it for the city court, Leon Valley's interpretation of these particular I think they're laws, but they might be ordinances. I think they might be like the general city ordinances, hometown, whatever. Texas has a weird way of doing uh, their cities. Certain cities can make their own special rules. Other cities have to use uh, specific rules that are promulgated by the state, etc. I don't really understand it, but whatever. It is what it is. But Leon Valley's interpretation is that because of the courtroom being in their city hall, that on court days they could prevent anybody from carrying firearms in there. Jack Miller's interpretation was that no, it had to be limited to like a distinct area somehow around the courtroom itself. I remember looking at the various attorney general opinions that he had provided on it, and if the courtroom was upstairs, then the attorney general's opinion was that you could then restrict the carrying of firearms in the upstairs portion of the city hall, but you couldn't prohibit it downstairs. Now, that's a attorney general opinions are great, but they're not binding, and a court doesn't have to follow them, and so by extension, Leon Valley didn't have to follow them, and it would remain up to a court to see what way it's going to go. Now, I haven't read all of this. I've read a few sections of this. It is 61 pages. I don't intend to go over everything. This particular attorney writes way too fucking much. Anyway, we'll see. So we're starting off on paragraph 41 of the Third Amendment complaint. While watching a video posted online from Mexican Padilla's visit to Leon Valley Municipal Building, Plaintiff Miller noticed that the Leon Valley Municipal Building had posted section 30.06 and 30.07 signs prohibited openly carrying and concealed carried handguns inside the building. Knowing that a city cannot prohibit handguns on government property by using section 30.06 and 30.07 signs, Plaintiff Miller, a Bexar County native, I'm going to say Bexar for the remainder of this, by the way, because I like saying Bexar County, and it really pisses off Texans who live in Bexar County, so I'm going to say Bexar County. Yes, I do know it's Bexar County, but fuck you, that's why. So Plaintiff Miller, a Bexar County native, decided to visit the Leon Valley Municipal Building to educate the city and or its police officers on proper signage and to submit a complaint form according to Texas Government Code Section 411 209D if they did not agree to take down their signs. Now, Miller's stupid. He's openly stupid. He is unrepentantly stupid. The police officers don't make the determination of what signs a city puts up. That would be up to the city manager, the city supervisor, the city council, etc. Audio is a bit low. Well, turn up your fucking volume then, because audio looks fine on my end. I don't know what to tell you there. I don't know what to tell you, boo. I'm max up all the way here. You know what? Because I'm going to be a nice guy. I'm going to go into filters, and I'm going to add a filter. I'm going to call it gain, and I'm going to take that gain up. Earbud listeners, fucking be warned. We're pushing up the gain on this, so I'm going to apologize in advance. All right, so we should have 10 dB gain. Audio is way too loud. You know what? I hate you all. I love you all and hate you all at the same time. How about that? So Jack Miller thinks he's going to educate police officers. Police officers obviously don't have to listen to a guy who, if he did any patrol, did very little. He was a jailer. I don't know why Jack Miller thinks he's in a position to educate police officers. He's not hired to do it. They don't have to listen to him. Why would they listen to him? I mean, he could, the correct thing to do for him would be to go to a city hall meeting, a town council meeting, whatever. And wasn't Jack an ex-cop? Says Denise Lynn. He was ex-sheriff. I am reasonably certain that he will never be hired by the sheriff again because of his performance. He was not a patrol deputy. He was placed in the prison where the people who are too fucking incompetent to be on patrol are placed. Let's just say that I have had law enforcement personnel from Texas, multiple ones, contact me to say that, how can I phrase this? To say that he would not be considered for hiring ever again, even if he applied. So he is not, and it's not based on his auditing. It was based on his performance as a deputy. So there you go. He was a jailer. Yes, WTT. He was indeed a jailer. So, but it's not his position to educate anybody. He should go to like a town council meeting or file a complaint with the city and petition the city to remove the signs. If that fails, his next step would be to file a petition in probably state court, since it's a state sign, to have the city remove those signs. But it's not, you don't go there and just try to tell the cops, look, cops, your understanding of the law is wrong. You should listen to me because I once was a cop and I didn't fucking cut the mustard. And so you should accept my expertise. So it continues on May 31st, 2018 at about 3:44 p.m. Miller visited the Leon Valley Municipal Building. Attached to his hip was a holstered black training prop designed to look like a handgun. He and a friend were filming his visit for their safety. When Plaintiff Miller entered the Leon Valley, isn't this picture helpful? This picture is so fucking helpful. Thank you for putting this picture in. The fucking clown show on this complaint. When Plaintiff Miller entered the Leon Valley Municipal Building, he asked Defendant Rivera. So the thing with complaints, by the way, is that the judge reads them. In most jails, the jailers are still sworn officers. Yes, he was a sheriff's deputy. He was a sheriff's deputy that was... So a lot of sheriff's departments will keep the people they can't trust to make independent decisions, to have good judgment, to exercise restraint. They don't let those people go out in public and act with discretion out in public. They keep them in the jails where they have constant supervision from superior officers, where there's always someone there who could say, Jack, you're being fucking stupid. Put the pink dildo away. The pink dildo. Yes, there was a pink dildo. And let's see if we can do this. We're going to open with, and we're going to go to Well, I made the thumbnail the picture of him with the pink vibrator. So there you go. Where are we going with this? Well, anyway, I forgot where I was in it. When Plaintiff Miller entered Leon Valley Municipal Building, he asked Defendant Rivera what was included in the building. Defendant Rivera saw Miller's fake handgun holstered to his hip and never indicated he was not allowed to be where he was standing with the fake gun. Does she have to? Is she obligated to? That's a great question, John, and I, for one, am glad you asked. Defendant Rivera recognizing Miller was not breaking any laws. Well, I mean, did she recognize that? Did she recognize that? I'm not sure about that. I mean, uh, at the point of the third amendment complaint, I'm not sure that they had done discovery yet. Um, I don't think. Strangely enough, I don't think that Defendant Rivera recognized, or at least would have testified to recognizing Miller was not breaking any laws. So Defendant Rivera informed Miller of the Building House, City Hall, Police Department, City Manager, Animal Control, and the Municipal Court. After confirming that the building was not just a courthouse, Miller asked to speak with someone to report the violation of the posted section 30.06 and 30.07. He actually asked to speak to someone to report what he believed to be a violation of the posted signs. And by the way, again, just for the record, I would be very pro allowing people to carry firearms in government buildings, including courtrooms and courthouses. I understand the inherent risk involved, but I mean, we do have bailiffs, we have armed security in courthouses, so I like it doesn't bother me. However, I recognize that a city or a state government can limit or restrict your right to act or your ability to access a state or city building with firearms, subject to state law. They have the ability to do that. So, my personal opinion is immaterial. Rivera required Miller to stand to the side and wait, which he did, while she brought Defendant Wills over to speak with him. Miller did not walk through the checkpoint, and he was not required to wait outside. Rivera knew that Miller had not walked into any court-controlled areas. And again, did she know that? You don't know that. I don't know that. This attorney who is writing this doesn't know that, and Jack Miller doesn't know that. So Plaintiff Miller, and again, another beautiful picture that really doesn't. Jesus, you can't see a goddamn thing I'm reading. There we go. Another picture that is just a waste of time and space on the complaint. Miller explained the situation to Wells and asked him to take the signs down. He also told Wells that he would submit a complaint to the Office of the Attorney General if Leon Valley decided to leave them up. Wells refused to take the complaint and required Miller to step outside with his fake gun. Okay, that seems reasonable. If there is a sign prohibiting you possessing the firearm in the building, requiring someone to step outside with the firearm seems like a reasonable action to take. A lot better, in my opinion, than arresting the guy on the spot. Defendant Tackard held open the first door for them as they exited the building around 3:46 p.m. Once outside, Wells forbade Miller from entering any portion of the City Hall again with his gun because it was a court day. He also told him to contact OAG's office, which is reasonable. Like, if you have a problem with our interpretation of it, take it up with the OAG. Maybe the OAG has the ability to not just issue advisory opinions, but maybe the OAG in Texas has the ability to require the city to change the way it enforces the 30.06 and 30.07. I don't know. I don't really care. I don't believe that Miller ever did that, so we don't know, and we'll probably never know. He also told him to contact the OAG's office, and Leon Valley would deal with them. So Leon Valley we'll deal with the OAG. That's appropriate. Do things what we like to call the right way is a great thing to do, but doing things Jack Miller's way generates Jack Miller revenue off of YouTube. Now look at this picture. This appears to be Jack Miller right here. You can tell from the girth. And does this look to be a fake gun to anybody else? Like, just looking at that, can you tell that that's a fake gun? I don't know. Defendant Wells refused to take the signs down, wished Plaintiff Miller a good day, and walked off. Well, thanks for the giant picture of Wells walking off. Whew, I mean, we're building a story here, folks. And again, remember, only the judge reads this. Only the judge reads this. Are these pictures really? Like, I have included pictures in complaints before, screenshots of maps, screenshots of intersections, like for personal injury complaints, screenshots of pictures of wounds for personal injury complaints, because if it's going to a judge, if a judge is going to be determining it, then it's going to be useful. That kind of stuff is useful directly for what I'm trying to prove, like on a map to show where the accident happened. Here was the intersection. Here's a map. If it's useful, like to show like where the lights are, etc. If it's useful, this is not useful. Showing Wells walking away, absolutely not useful. Showing somebody shaking Miller's hand, not useful. It's just it distracts from all of the useful stuff. GMK says, just end firearms inside any building. How about you not? How about we not do that? I'm trying to be nice. After watching defendant Wells walk off to the parking lot, Miller turned around and saw Anderson standing in the door to the building. Anderson had been informed by Leon Valley Criminal Investigations Division, Sergeant Eddie Gonzalez, of Miller's visit and was waiting to speak with him. Miller asked Anderson if he was an official willing to talk. Anderson agreed, and they both shook hands. Anderson then told Miller that he was allowed to practice his First Amendment right until his ears bleed. I mean, again, the Bio Explorer says the picture actually makes it look like it was reasonable to not know if it was real or fake. Yes, it is freaking loud, and like he's probably 10 feet away from me, but he's like crowing at my ear. You're a real dick, Fabio. You're a cock. He's a cock. He's a real cock. So Miller told Anderson he was not there for that being practicing his First Amendment. But he really was. He just doesn't understand. The petition your government for redress of grievance, which is what Miller was there to do. He just didn't really understand what he was there to do. It is a First Amendment right. So, yes. So Miller informed defendant Anderson he was not there for that. He then explained to him about the Section 30.06 and 30.07 signs. Again, Miller explained to Anderson Miller's interpretation of the Section 30.06 and 30.07 signs. While Miller was explaining, Anderson interrupted him to tell him he would not argue the law with him and to contact the OAG's office, the Office of Attorney General. Which again, like you would think that Miller would have done. I remember making a video on it explaining that these are some of the steps that Miller could take, and I don't know if Miller ever did it. That's where he should have started anyway, if he actually wanted to make a change. If he didn't want to make a change, he wanted to make a YouTube video. Miller asked if Leon Valley could look at the law themselves when someone had the time. And that's like Leon Valley has an attorney, or had an attorney, a city attorney, and I am reasonably certain that the city attorney looked at it and made a determination on those signs. So, I mean, that's what they paid the city attorney to do. Anderson insisted that he believed Leon Valley was in compliance with the law and they were entitled to post those signs because the building was also used as a courthouse. He then informed Miller he would not give him a confrontation, to have a good day, and not block the entrance. When Miller protested he was not there to provoke a confrontation, Anderson walked back inside. Well, Miller saying, "I'm not here to provoke a confrontation," doesn't mean that Miller wasn't there to provoke a confrontation. He was there to provoke a confrontation. You can tell he was there to provoke a confrontation because he painted a training pistol black to make it appear to be a real pistol and carry it in to provoke a confrontation. He was literally there to provoke a confrontation. Amazing. And I guess this attorney thought that having Miller protest he wasn't there to provoke a confrontation would somehow persuade the judge, after all of this, that's true. And it beggars belief. While Wells had been speaking with Miller outside, Defendant Rivera had informed Tackard that members of the group, quote, audit, were being contacted by Officer Jim Wells. Tackard proceeded to watch the interactions between Miller and Wells and Anderson from inside the building. He was joined by Gonzalez. Useful information. Once Miller moved away from the front of the building, Anderson and Gonzalez, Tackard, and Rivera huddled together to discuss their next steps. What? They actually thought about what they were going to do? They gave each other advice on how best to proceed instead of just acting and reacting? Crazy. How dare they? How dare they think about what they're going to do before they do it? How dare they? Unreasonable. Unreasonable. Neither Anderson, Wells, Tackard, or Rivera appeared concerned about the presence of Plaintiff Miller's handgun or acted as if they believed him to be an actual threat to security. Now, the restriction on carrying the firearm does not require you to be an actual threat. You just aren't allowed to carry a firearm into the building, into a courthouse. God damn mosquitoes. Land, you little bitch. Land. I will fuck you up. I will fuck you up. Goddamn mosquitoes. They love my ankles more than anything because I have sexy ankles. You know what a burden it is to go through life with sexy ankles? Nate knows what it's like to go through life with sexy ankles. Isn't that right, Nate? So yeah, it doesn't matter if he's an actual threat to security. The key issue is whether or not he had a firearm inside of the restricted area, the area that he's prevented by 30.06 and 30.07 from carrying a firearm into. None of them escorted him away from the doors to the building. Okay, are they required to? No, they're not. So that's kind of weird. None of them examined his prop weapon or performed any other investigations. Were they required to? No, they weren't. None of them arrested him on site for stepping just inside the Leon Valley Municipal Building wearing a supposed handgun. Officers have what's called discretion. They can choose whether or not to make an arrest. Uh, Generally speaking, I mean, sometimes states will take that discretion away from them. Like it's very common if the police are called for a domestic violence call, they are required to arrest somebody. Um, so um, that's one instance where the state can take away discretion. But generally speaking, officers have discretion because it's the officer who needs to have probable cause on whether or not a crime occurred and the person they're arresting is probably committed the crime. So they're imbued with discretion. So they can take their time and investigate before they arrest, or they can choose not to arrest. Even if they believe that someone committed the crime, they can choose not to arrest. How many times have you sped past a cop on the freeway where you were obviously indefinitely speeding, and yet the officer doesn't pull you over? Officers have discretion, even if you're dead on violating the law. They have discretion. None of them arrested him on site for stuff being just as okay. Rather, upon information and belief, they were more concerned about him belonging to a so-called auditor group and felt his supposed membership with this alleged group was the real threat. Well, that's weird because they said that you can be in here as long as you don't have the firearm. So that's weird, right? If they're more concerned about him being a member of this auditor group, then why were they saying you can come in here as long as you don't have the firearm? You just can't bring a firearm in here. That's kind of weird, isn't it? Isn't that weird? I think that's weird. I would posit, on information and belief, that they were more concerned about him carrying a firearm into a restricted area, or what they believe to be a restricted area, than him being a member of a so-called auditor group. While defendant officers discussed his visit inside, Miller returned to his car to store his prop handgun. He then returned to the municipal building. As Miller approached the building, the four officers scattered, trying to act casual. Or they were done with their conversation and they moved away from each other to go about their other things. Defendant Rivera resumed her security post. Well, thank you for that bit of information. Anderson and Takar took up positions throughout the entry hall, and Defendant Gonzalez stood in the side hallway near Defendant Rivera, partially hidden by the wall. It occurs to me that this Miller guy had just attempted to bring a firearm in. He went to his car, ostensibly to store the firearm in the car, but did they see him store the firearm in the car? And if he did store the firearm in the car, does that mean that that was the only firearm he had on him? So why wouldn't they? Why wouldn't they continue to monitor him since he clearly believes that he has a right to have a firearm in that area, and he clearly believes that the officers are misunderstanding and misapplying the law? There is a possibility that he would attempt to bring a firearm past their checkpoint, etc., or otherwise cause a problem. Because, as we all know, auditors love to cause disturbances. It's kind of like their thing. At about 3:51 p.m., after re-entering the building, Miller was wanded by Rivera, who was performing security checks at the door. Once Rivera cleared him to enter the building, he approached the front desk to ask the receptionist for a complaint form. While filling out the form, Miller informed Rivera, and by proximity, Gonzalez, who was lurking in the side hall. And I love the writing style. He was lurking in the side hall. It just makes he's the attorney should do more creative writing, I guess, because he really is painting a picture of these officers being terrible, evil people. The problem is, if you watch the video, they're not. Uh, and Defendant Tackard, who was standing to the other side of the foyer's double doors, so Plaintiff Miller informed them all that he does not endorse Mexican Vidia's actions. He was just there because he saw the signs on the door. Well, again, what Miller says and what he actually believes aren't necessarily the same thing, and the officers don't have to believe him. Miller also told these officers he wanted to give them the opportunity, quote, to shine. And again, what the attorney is trying to say is that Miller was there, to help these officers out. He's doing them a solid by being there. He was trying to give them the opportunity to shine. But to shine means that these officers would have to accept Miller's interpretation of these particular statutes or ordinances. that prevented people from carrying firearms into courthouses. And again, they're not required to listen to some schlub off the street. Like, he's not an expert. As much as he wants to be an expert, as much as he wants to be seen as the guy who educates police, he is not now, and he will never be that guy. He's just some schmuck off the street who happened to once be a sheriff's deputy. Well, you know what? Who's that other fat retard? Chief Damon Jones was also multiple times employed by various law enforcement agencies, and he's also not an expert. Again, he also tries to pretend to be an expert, but he also, just like Jack Miller, can't get hired anywhere. I had one sheriff send me Damon Jones's entire unredacted social security numbers and everything, completely unredacted application to be a sheriff's deputy. I was flabbergasted. This sheriff hated Damon Jones so fucking much, that he was just like, have everything on Damon Jones. I'm going to let you investigate Damon Jones until the end of time with all of this information. Unbelievable. So he sent me Damon Jones's date of birth, social security number, mother's maiden name. He sent me that fucker's birth certificate. He sent me the fucker's birth certificate. I was like, oh my god. Yeah, so that was a terrible thing for that sheriff to do, but like active law enforcement don't have to listen to washed up law enforcement. They don't have to listen to officers who couldn't actually make it as officers. When Cicito, who had been informed of Miller's presence by Anderson, appeared in the lobby around 3:54, Miller informed him that he was not there to do First Amendment stuff or create problems. Cicito acknowledged his statement. So acknowledging his statement doesn't mean that Cicito necessarily believed it. And I believe at this point, Miller was filling out a complaint form, which is again petitioning the government for redress of grievances. It's again having him communicate something to somebody, which is First Amendment activity. So he's literally fucking there performing First Amendment stuff. By filling out a complaint form, he is there performing First Amendment stuff. Congratulations, Miller. You're a fucking retard. 6 minutes after Miller entered the building the second time, at about 3:57 p.m., while he was standing there quietly filling out his complaint form. Is he quietly filling out his complaint form, or is he talking to people? Oh, it goes on. Quietly filling out his complaint form at the front counter and politely chatting with the receptionist. Is he quietly doing it, or is he chatting? I don't know. Orange Cone says, pouring down rain, a man runs a stop sign. When a cop pulls him over and asks, do you know why I pulled you over? Man answered, do you know why I ran the stop sign? As water runs off the cop's hat. That is a terrible thing to do, Orange Cones, because the man just admitted that he ran the stop sign. This is why, no matter how clever you think you are, don't talk to the police. Because you admit things. People admit things all the time they don't realize they're admitting. Even attorneys are well advised not to talk to the police. He informed his friend. Ooh, I love all the pronouns. Miller informed his friend, I guess. Miller informed his friend that he had received a text message that LVPD was already discussing potentially arresting him for entering the building with an alleged gun. So that is a long way of saying that Miller received a text message alleging that LVPD was already discussing potentially arresting him. Now, I don't know exactly why that's important, but okay. Miller informed his friend, the receptionist, and Rivera that if LVPD chose to arrest him, Once they searched his vehicle, they discovered that his so-called weapon was really a rubber gun, and perhaps they would be willing to finally listen to him. Again, LVPD does not have to believe. They don't have to believe Miller. They don't have to take him at his word. Well, the unarmed GMK says auditors are just fighting for freedom. Well, some of them are just fighting for freedom. Some of them are fighting for YouTube revenue. Painting with a broad brush rarely does anybody any good. While the unarmed Miller filmed himself completing his complaint form. I mean, that's important to add that he was unarmed there because we didn't fucking know that already. At about 4:01 p.m., Brooks meandered into the lobby and took up a position leaning against the side counter of the receptionist's desk. Again, useful information. A minute after his arrival, the receptionist, who had been working on her computer, immediately stopped what she was doing and promptly packed her belongings. Then, in the middle of a busy court day, it's 4:01 p.m. That's not the middle of a busy court day. Courts, generally speaking, don't last until what, I don't know. How could that even be in the middle of court day? I guess if it started at noon and went to 8 or something. I don't think that works that way. So how is this even remotely in the middle of a busy court day? And when did they establish that it was busy? What is the metric for busy? But she left the receptionist's desk unmanned for the remainder of Plaintiff Miller's visit. Well, how long was Plaintiff Miller's visit? And if it was in the middle of the court day, then maybe it's time for her to take her lunch break, because usually lunch breaks are done in the middle of your shift. Or maybe she started at around 7 o'clock in the morning and she was done at around 4 o'clock in the afternoon, which is not unreasonable. Maybe. I don't know. Maybe she had other things to do. Why do we fucking care about this? Like what is this adding? Like this is great for building a scene, but a complaint should address the elements of the particular cause of action. If you need to prove X, Y, and Z, your plaintiff or your complaint should prove or should offer facts that support X, Y, and Z. Captain Clown says no matter how many times you tell them, they won't listen because people think they are smarter than they actually are and can't be told that they aren't until shown otherwise. Most people do believe they're smarter than they are. That is true. That is the whole Dunning-Kruger effect. Oh, can I get this? Oh, can I get you? Damn it, got away. Uh, I live in Mosquito Central out here. At around 4:06 p.m., Brooks left his post. He returned around 4:10 p.m. and, per orders given him by Defendant Anderson, casually set up a body camera on a nearby table and focused his camera on Plaintiff Miller, which, I mean, they're entitled to do. There's probably also security cameras available in there, but they wanted a body cam, so that's great. You know what? Auditors are all about recording their interactions with the government. And so why would Jack Miller in his complaint even bring this up? Why would he even bring this up? He then resumed standing nearby, leaning against the side front counter. Like, isn't this like what auditors think they should be able to do? So if an auditor should be able to do it, why shouldn't a cop be able to do it, right? And in this particular case, the cop was in his police department, so I mean, he's not even someplace he's not welcome. Defendant Anderson joined Brooks, standing at the side, and quietly asked him. So Anderson asked Brooks if they'd been able to identify Miller yet. Brooks told Anderson that they were looking him up right now, but he knew that Miller was included on the sheet. I don't know what sheet that is, don't really care. He was not sure what Miller's name was or where he had placed the flyer, but he was confident Miller was on it. Okay, so now they're trying to identify him without demanding his ID. Isn't that the preferred course of action? Like, we know in Texas, 3802 prevents cops from demanding your ID, from forcing you to identify yourself until you've been arrested. So, like, what's wrong with them, like, trying to understand who you are without violating the law? Seeing the two officers quietly conferring to the side, Miller, who had just finished completing his complaint form, asked them, "Are you guys out here for this?" Brooks, who had just set up a camera to record Miller, claimed he was out there for the court, but Anderson asked him what it was. Miller explained the form to him, because Anderson obviously didn't know what a complaint form was. But Miller, believing that his goal in life is to educate the police, doesn't understand that the cop was just shining him on, and so Miller explained the form to him. While Miller tried to explain what information he had provided on the complaint form, Anderson told him, "Go ahead and try to solicit your confrontation. Go ahead." When Miller informed Anderson that he usually did not get a problem from police, Anderson denied giving him a problem and insisted he was just there to take the complaint. When Miller pointed out that Anderson had been confrontational from the very beginning, Anderson interrupted him and demanded he tell him his complaint because he was a busy man. Well, wasn't Anderson the guy that they shook hands with twice? Didn't we have a picture of him shaking hands twice? Well, we have one picture of him. Oh, look, Anderson and blah, blah, blah. And they shook hands. They both shook hands. Yeah, there you go. There's Anderson shaking his hand. Wow. You then informed Miller you would not give him a confrontation. Yada yada. Walk back inside. Boy, that's. Oof. This Anderson guy. Boy. Miller informed Anderson that if he was too busy, he would find someone else. Anderson claimed he was here to handle it, but then immediately informed Miller again, "I'm not going to give you a confrontation, promise." Well, that's terrible. It's terrible when someone says, "I'm not going to be confrontational with you." I mean, I really get upset when someone tells me I'm not going to be confrontational with you. Really, I'm really like, "What? You're not?" Like, those are fighting words where I come from. When Miller asked him to stop what? To stop not giving a confrontation? Anderson told him that was what he wanted. When Miller asked him to stop, Anderson told him that was what he wanted. Miller says, "I'm not here to give you a confrontation." No, Anderson informed Miller, "I'm not going to give you a confrontation." Miller said, "Stop. Stop not giving me a confrontation." And Anderson says, "Look, this is what I want, to not give you a confrontation." Miller again asked him to stop not giving a confrontation. Anderson informed Miller that he had his complaint. Anderson informed him that he had his complaint. Fucking pronouns. Fucking pronouns. I'm not talking about the LGBTQ stuff. I don't care about those pronouns. I just don't care. I care about pronouns in a complaint. No one knows what the fuck you're talking about if you use pronouns like this all the time. Anderson informed him that he had his complaint. Who the fuck are the he and his? Anderson informed Miller that Miller had Miller's complaint. Anderson informed Miller that Anderson had Miller's complaint. Anderson informed Miller that Miller had Anderson's complaint. Who knows? You don't know. I don't know. The court doesn't know. This is shit writing. Absolute shit writing. Raider says, "The story is really long and boring. I want more spice and drama to keep me awake. How many pages is this brief anyway?" We're on page 18 out of 61. I'm not entirely sure I'm going to go all the way through it. I really intend to get through the allegations and charges through the raid. Once I get done with the raid, then I'm going to go to the judgment and the motion for reconsideration. So, sorry, Laura. Plaintiff Miller insisted that Anderson return his form. He would find another officer to discuss it with. Well, he insisted it. Miller also asked Anderson for his name. Anderson provided it, but Miller was unable to hear it. He asked Anderson to repeat it, but Anderson refused several times, even when Miller introduced himself and told Anderson he did not remember hearing him give his name. Okay? That's like a policy violation at best. Miller then tried to discuss this complaint form with Captain Saucedo, who was also lingering in the front hall. Defendant Saucedo informed plaintiff that the lieutenant usually handles these matters. Miller explained he had tried to talk to Anderson, but Anderson had been confrontational from the moment he walked in the door, and he kept interrupting him. He kept interrupting him. I'm not sure, Laura, that anybody paid for this because you know, spoiler alert, uh, Miller lost, and I would bet a nickel that this had been taken on a contingency basis. So I don't think the lawyers got paid anything for this. This just appears to be this particular lawyer's style, and as grating and annoying as I find it, like all these pictures of handshakes. Man, thank God we got pictures of handshakes. These handshakes really make the officers look bad, doesn't it? Anyway, Saucedo pulled plaintiff to the side, away from the people waiting by the courtroom, to discuss plaintiff's complaint form. Miller explained his concerns to Saucedo about Section 3006 and 3007. Miller also told Saucedo he wanted to use his video to show that Leon Valley acts differently than they were shown in Padilla's videos. Defendant Saucedo and Miller shook hands twice during this conversation. Now, speaking of which, I know that they reached a settlement in the Padilla case, or well, the one with against Salvaggio, where they incorporated Tucson police suck, his complaint about his uh, treatment when he tried to interfere in the arrest of Padilla. That was combined in there. I know people think that that's a win. It's a settlement. I want to I want to advise everybody that this particular case went to a settlement conference. There was an alternative dispute resolution / mediation, and it didn't settle. The parties were willing to go to mediation. Now, they didn't reach a mediated agreement, um, but they could have. And Miller could have been paid out of this. Now, as we know from the order granting summary judgment in favor of Salvaggio et al., we know that on the merits, Salvaggio et al. Had a better case, but it still could have settled. All cases have settlement value. Go away money, says Devin E. Well, yeah, the defense. Their attorneys aren't working on contingency, and so they have to figure out how much it's going to cost to go all the way to trial, deal with all the bullshit, and then there is still always a chance. There's always a chance that at trial you can lose. The jury could favor the plaintiff. So all those considerations come into play when figuring out whether or not you're going to settle. Even if you think you have a winning case, you might settle and pay up a little bit because it's cheaper in the long run. You might do it. And even if you have a losing case, you might take it all the way to trial because you wanted to deter people from trying to come after you for cheap, quick settlements. There's a lot of different strategies that defendants take, and it's generally speaking done on a case by case basis where the defendant works it out with their attorney what they think the best course of action would be. After taking pictures with his phone of his filled out complaint, Miller gave Saucedo the form and offered to do a follow up video, hopefully showing Leon Valley in a positive light. Miller then left Leon Valley Municipal Building, believing that this incident was over. His belief that the incident was over is irrelevant. Most of this shit is irrelevant. Instead, a defendant officer informed Sergeant Joel, a patrol sergeant, of Miller's visit to the Leon Valley Municipal Building. The sergeant, in turn, ordered Breton to surveil plaintiff from a parking lot across the street of the building because plaintiff had, quote, caused alarm by the lobby area of the municipal building. Okay. That is probably Sergeant Joel's interpretation of what a defendant officer had said. Before leaving the park, and it's, again, if Miller's in public and he's being surveilled in public, I don't understand why they fucking care. It's not a violation of your rights for the police to surveil you from a public place. Before leaving the parking lot, Miller smoked a cigarette with his friend approximately 20 minutes later. Again, who the fuck cares? Approximately 20 minutes later, he got in his vehicle and drove out of Leon Valley. Who cares? While Miller left the area in his vehicle, obeying all traffic laws, Brett ran his license plate number through a police database. Well, first of all, did he? Did he? And second of all, who cares? Now, you're going to say, I know you're going to say that you're not allowed to run someone's license plate for personal reasons, and that's true, but they had probable cause by this point that Miller had broken the law, and so he ran the plate because he had probable cause that Miller had broken the law. Officers had seen Miller take something that appeared to be a firearm into the courthouse, and they have not done anything to dispel that other than what Miller said. Miller said it was a fake gun, but they don't have to believe him. They saw something that looked like a real gun. This search, the approximate time of it's not a search, it is not a search. Running someone's license plate number through a police database is 100% not a search as far as the Fourth Amendment is concerned. Now, they searched the police database. Okay, that's a valid use of the term in English, but this is a complaint. And he should use terms as they would be legally understood. It is not a search for them to run the plate through the police database. With the complaint in hand and running Miller's license plate, Salvaggio and Leon Valley police officers quickly learned that it was in fact Jack Miller that visited Leon Valley, a perceived member of one or more auditor groups. Well, unless I'm retarded, Miller introduced himself and so Miller already introduced himself. So didn't they already know that he was Miller? Didn't they already know he was Miller? Am I misreading that? Like, they confirmed that the vehicle was owned by someone named Jack Miller by running the plate, but did they confirm that it was Jack Miller that visited Leon Valley? I don't think they did. They had someone who introduced himself as Jack Miller, and the vehicle that the person came to the courthouse in was owned by Jack Miller, a perceived member of one or more capitalized auditor groups. Close to an hour after Miller left the Leon Valley Municipal Building, a defendant officer, unknown apparently, asked Vasquez, who had not observed any of the events that occurred, to speak with Rivera about what she had witnessed and to write a police report for a place weapons prohibited charge. The police report was not entered into the system until about 5:45 p.m., over an hour after Plaintiff's departure. Well, I guess we're on a time frame. That whole 15 minutes to detain has now turned into you have to file a police report within an hour of the plaintiff's departure or something. I don't know. Officers could have arrested plaintiff on the premises for the supposed crime he committed, but they knew he did not commit one. Did they know he didn't commit one? Because you just told me that she wrote a police report for a place weapons prohibited charge. It sounds like they did not know that Miller had not committed a crime. See, that's the problem with writing like this is trying to make all of this shit into a story. You're making mistakes. This changed once they confirmed this. What is this? They knew he did not commit one. This changed once they confirmed. So once they confirmed that he was a part of the auditor group, then they knew he did commit a crime or something. I don't know. I don't fucking know. What shitty writing. I am so sorry. As a result, an officer who was not present during the interaction was the one to report the crime. No, the officer who's not present during the interaction was one who wrote the police report. Those fucking guinea fowl are so loud and obnoxious. Anderson later claimed in his police report that he made the decision to allow Miller to fill out that form and leave without stopping him or even initiating arrest for supposedly bringing a gun on the premises because, quote, his activist group and affiliates are known to cause major confrontations when arrest is imminent and drastically overreact and even resist arrest in order to capture the video and post it on social media platforms. It was determined an arrest warrant would be obtained instead of an on-site arrest and risking injuries or possible social media inspired disturbances. Well, that seems pretty reasonable. We already know what happened with Padilla's arrests, plural. He resisted both of them. We know that Tucson police sucked, intervened in the arrest of Padilla, and I get it. He got a settlement out of it, but I'm not entirely certain that had it gone to trial, he would have prevailed. In fact, I would guess, if I had to guess, that if it had gone to trial, he would have not prevailed because he might not understand this, but outside of his limited circle of people who share his beliefs, the broader society look at people like him and people who do the things that he can do as douchebaggery. And most people don't want to see people intervene in other people's arrests. But knowing that these people out there are resisting arrest and doing things like that, and knowing that, or believing, I should say, that Miller was armed, it seems like a reasonable idea to be like, okay, if he's recording it like we know he's doing, he might want to make a scene out of it and or resist arrest. And if he's armed, that could lead to someone getting shot, including Miller. Miller could get hurt or shot. And so they thought it might be a better idea to get him when he's not prepared for it, where he's going to be less likely to resist. Now, say what you will about police raids. I am not a fan of them. The police are under the belief, and it might or might not be supported by data, I'm not sure, but the police are under the belief that if you get someone at like between midnight and 4 a.m., they're more likely to be asleep. They're less likely to resist. They're not going to be awake, aware, and armed, generally speaking. Upon information and belief, so again, this is shit that he doesn't have any fucking idea about. Officers used Miller's alleged membership in one of these supposed auditor groups to justify their treating him different from every other citizen present that day and to justify the long delay before they chose to charge him with a crime. Well, what other citizens present that day carried something that appeared to be a firearm into the court or into the building? What other citizens that day brought a firearm into that building? And how were they treated? And why can't officers use their knowledge of someone to color their reaction to that person? Like when officers go to arrest someone, if they know it's a violent armed felon, they're probably going to treat it differently than if they know they're going to arrest someone who's a failure to appear on a drunk driving charge, no other priors, no history of violence. They're probably going to approach those two things different because they have information about them that warrants the different treatment. Alleged membership in a gang might get you treated differently than alleged membership in a church choir, maybe, and probably reasonably. Miller's every interaction with each police officer he encountered during his visit with the LVMP or with the Leon Valley Municipal Building, his visit to the LVMP or LV municipal building was tainted by their stubborn adherence to Michel Barrientos Vela's pernicious theory. So Michelle Barrientos Vela was a shitty constable. She was a constable, right? She was a terrible person. I did videos on her. But Leon Valley, she did not work in Leon Valley or for Leon Valley. I believe she had there was some accident scene that she tried to have her constables take charge of that I think was in Leon Valley, and they had a confrontation. If I remember correctly, I could be wrong on that. I probably am, but she has nothing to do with Leon Valley. She's not. She's not like. Eh. I don't know why they're. I don't know why he's bringing Bella in. My guess would be because she has been discredited. Like she has been charged with crimes. I think convicted, and she's no longer a constable. I think they're trying to like guilt by association, Leon Valley. Their stubborn adherence to Bella's pernicious theory about groups organized to harass police officers under the guise of exercising their First and Second Amendment rights. Well, if there weren't auditors going out in groups to harass police officers under the guise of exercising their First and Second Amendment rights, then this theory wouldn't make a lot of sense. But there are groups, there are people, there are auditors who go out in groups, and they go out with a purpose to harass police officers, generally speaking for clicks and views, under the guise of exercising their First and Second Amendment rights. It did not matter how politely Miller spoke with the police officers. They viewed him as a criminal and treated him accordingly the moment he stepped through the door. The moment he stepped through the door with what appeared to be a firearm in violation of Section 30.06 and 30.07, they treated him as a criminal. They viewed him as a criminal. They viewed someone who they had probable cause to believe was breaking the law as a criminal. His operative theory is that the police officers viewed someone who they had probable cause was committing a crime as a criminal. Exactly. That's Inigo, by the way, crowing back there. Sorry, Captain Clown. My apologies. He's probably going to crow a few more times. He has the puffed out chest going on. He's got "For the Ladies" right there next to him. Anyway, former Police Chief Salvaggio's next move. Upon information of belief, following Miller's departure, officers used the information he provided on his complaint form to identify him. So Miller introduced himself. Then he left, leaving behind the complaint form, which apparently had his identity on it. Then the officers ran his plates to confirm his identity. And now, of the three, the defendant officers used the information that Miller had provided on Miller's complaint form to identify Miller. Salvaggio, who remembered Miller from his Bexar County days and knew he was a political activist, realized that this was the situation he had been waiting for. We didn't put this in on information and belief. Miller filmed almost his entire visit to the LVMD or LVMB. He had also visited while wearing what appeared to be a handgun. Yeah. Salvaggio concluded that Miller must be the link between First Amendment officers and Second Amendment auditors. Well, did he? And that's giving Miller a lot of credit that I don't think Miller has. Is Miller that link? Does like I haven't really been keeping up with Miller. I am subscribed to him. I rarely watch his shit though. I find him to be, eh. But does anybody really give Miller that much credit? Does anybody really think that he's the link between First and Second Amendment auditors? Yeah, that's a bit of a stretch. He knew his officers could not prove Miller had. I mean, as much as I despise Chicken Hawk, what's that? Tiny Grisham, something Grisham, Tiny Grisham, C.J. Grisham. As much as I despise C.J. Grisham, and as stupid as that motherfucker is, he is more of a link between First Amendment auditors and Second Amendment auditors than Miller is. So he knew his officers could not prove Miller had committed a crime. Miller knew Salvaggio's officers could not prove Miller had committed a crime. But again, like, did he know that? Did he know that? Did he know that officers could not prove? We have pictures included in this complaint of Miller carrying what appears to be a firearm. Yes, Miller is Texas Sheepdog 72. So why would he think? And here's the fucking fun fact. I know that Salvaggio got a fucking warrant. So a magistrate or judge, I'm not sure who he got the warrant from, concluded that there's probable cause that Miller had committed a crime. So Salvaggio probably thought that he could prove Miller had committed a crime, and he convinced a judge or magistrate that a crime was probably committed. Plaintiff Miller had never entered the court areas. Now, again, we're going to an opinion by the Attorney General. And the opinion is that these particular sections only ban firearms in, quote, a government courtroom or those offices essential to the operation of it, the government court, end quote. The entire building that happens to house a courtroom does not qualify as a premises of court. The court areas must be further limited to just the essential court offices and courtrooms. License holders must be notified of their inability to carry it. So the quote ended, and then all of this is not part of the quote. So the quote is, quote, a government courtroom or those offices essential to the operation of the government court, end quote. Now, if you look at just the quoted language, it doesn't appear, just the quoted language, does not appear to have a verb in it. And I like it when quotes have a verb. No offense, Merb, but the impeachment trial of Texas AG Ken Paxton has been much more entertaining. Well, then go watch it. I'm not trying to keep anybody here. They do not have the supposed weapon he was wearing while in the municipal building in evidence, nor had any officer inspected the gun to determine if it was a real weapon. So now what the attorney is saying is that apparently the officers have to arrest someone or do at least a Terry stop on them and disarm them in order to be able to prove, or in order to be able to have probable cause that someone's carrying a firearm. They have to inspect the firearm before they have probable cause. I don't think so. Miller also represented that it was a rubber toy. Well, again, the officers don't have to believe someone who they think is committing a crime. Because, imagine if the officers had to believe them, then every criminal ever arrested who said, oh, I didn't commit a crime, I didn't do nothing. Every criminal ever says that. Hashtag not all, whatever. But it's almost routine that criminals deny committing the crime. So why would they have to believe the person who they suspect of committing the crime? However, Salvaggio believed he could use their testimony that they believed it was a real handgun and some highly simplified descriptions of the building in question to manipulate the circumstances in his favor. Wow, is that what Salvaggio believed? I mean, we've got a psychic over here, folks. Salvaggio instructed his officers to proceed with charging Plaintiff Miller. At about 5:45 p.m., close to an hour after he drove off, we've already had the close to an hour after he drove off, Vasquez entered his police report into the system, and the other officers began adding their supplemental reports concerning Miller's visits. The police report, which reported Miller's supposed crime, was not completed by an officer present during Miller's visit. But what about the supplemental reports? Were those? And here's a fun fact. Most police reports are not entered by a person who was actually present during the crime. Most police reports are when the officer goes out and takes a police report. He takes the statements of the witnesses. Then the officer who did not witness the crime goes back and enters the police report into the system. So literally, that is literally what police reports are 99.9% of the time, is a police officer going out, getting the eyewitness testimony, and then the police officer who did not see anything, who was not present during the alleged crime, would go back and enter the police report into the system. That's what's supposed to happen. This guy's holding this out like this is some like gotcha fucking moment, but that's literally what's supposed to happen. Instead, Vasquez was ordered by Salvaggio, yada yada, to interview Rivera and write the report. Yeah, that's normally you interview the fucking witness and then you use that in your report. And did they? Putting in that it was ordered. I mean, yeah. Vasquez consequently could not rely on his own suspicions, beliefs, facts, or even knowledge of the circumstances he witnessed to use in reporting the alleged crime. Fucking idiot. Instead, he relied on others' portrayals of the events that occurred. Yeah, I did. That and this, upon information belief as intended, resulted in inaccuracies in the information included in the report, such as the claim that Miller, quote, moved further into the building uninvited, arguing with officers and detectives while having the weapon clearly visible and displayed a handgun clearly visible in plain view on his waistband, thereby violating places weapons prohibited 4603. I mean, did he, didn't he? I don't know. Was that an inaccuracy? I don't know. And what does move further into the building uninvited mean? Well, he's not invited. And how much further does he have to move in? If he steps just inside the doorway, he's in the building. If he takes one more step forward towards the screening location, he's now moved further into the building uninvited. Did he argue with officers and detectives while having the weapon clearly visible and displayed a handgun clearly visible? Sure, he was arguing that 3607 and 30.06 and 30.07 didn't apply. Is that an argument? Sure, in the technical sense. I mean, it doesn't have to be heated in order to be an argument. Fucking hell. Rivera wrote in a report and proceeded to tell Vasquez that Miller entered, quote, municipal court, end quote, with a firearm. This is blatantly false and known by defendants to be false. The municipal court building, maybe? I mean, because that's a very short quote. One of the things that they have to allege is the elements of a crime, and if the 30.06 and 30.07 apply to municipal courts, then they'd have to allege it's a municipal court. Now, where does the beginning and end of the municipal court lie? And if we go back to the Attorney General's opinion, it's a government courtroom or those offices essential to the operation of the government court. Is the security screening station essential to the operation of the government court? Maybe. I don't know. Laura Rader says, Bexar County, if you please. The X is silent, but it's there. You must have missed it earlier on. I do understand it's Bear County. And I say Bexar all the time because it annoys people like you. You're welcome. You're welcome. I know you live in Bexar County. So enjoy the X because the X is there. In reality, Miller entered Leon Valley's City Hall and respectfully asked Defendant Rivera, again, how respectful he was is immaterial, after she confirmed the building was not a court. So again, this is like one of those things. Is this building a court? Well, kind of depends on what you mean by court. Is it a courtroom? Is it a courthouse? Does it house a court? Does it contain the court and the offices necessary to for the function of the court? And Defendant Rivera's understanding of whether or not it is a court is immaterial. She wasn't the arresting officer, right? To speak with someone about the signage, moved a few steps to the side after speaking with Defendant Rivera to allow other individuals to enter the building and to signal his location to Defendant Wells and cordially explained his concerns to Defendant Wells. Defendant Vasquez's inaccuracies magnified Plaintiff Miller's alleged crime. The alleged crime is that he entered the fucking courthouse, or the Leon Valley Municipal Building, which they believe Section 3006 and 3007 apply to. He entered that building with a firearm. That's it. All this other shit is immaterial. Salvaggio wanted to go after Miller and his family. He wanted to make it personal. Citation fucking needed. He also wanted to collect whatever he could to prove his theory correct, that there are these organized auditor groups engaged in criminal activity. Again, citation needed. His intent was to use this interaction to seek a warrant to conduct a midnight raid on Plaintiff's home. That is probably true because he did use this interaction to get a warrant to conduct the midnight raid on Plaintiff's home. He met with defendants. Wow, he met with defendants. That's crazy. Defendants put together a narrative that would allow them to seek a search and arrest warrant. You know what that narrative would be? That narrative would be that Jack Miller entered the Leon Valley Municipal Building on a court day where weapons were restricted pursuant to 3006 and 3007. And he entered that building with a weapon. Ta-da! I mean, which one of those things are you disagreeing with? It's not a hard narrative to put together. To insulate Officer Rivera, since she knew that Defendant Miller died, how did Defendant Rivera know that Miller didn't have a real firearm? How did Defendant Rivera know Miller didn't have a real firearm? That's a great question. I'm glad you asked. And the answer is, I don't fucking know. GMK, you can visit my, she, I believe, I don't want to misgender you. Sir and or Madam, GMK lawyer at law, asks, can I pay Merv to end this? The lawsuit has been ended. Well, mostly ended. There is a motion for reconsideration. And if you want me to stop reading it, you can go to my G-String account and donate heavily there. And I might consider it. Or I might not. Because really my G-String account is for your benefit, not for mine. Vasquez agreed to write the report, even though he did not witness any crime. Again, this is stupid. You're beating a dead horse. King then agreed to prepare the affidavit based on Vasquez's report. Okay. King. I don't know. I don't know if King saw anything. Defendants knew the report's affidavit concerning Miller's conduct was not correct, but they chose to lie anyway. Well, what was the lie? Instead of saying they lied, what you do is you show what happened, and then you say what the report said, and then you point out the errors. Captain Clown asks, did Rivera handle the suspected weapon? No. No one handled the suspected weapon. At least not on that day. Other officers, including defendant officers, added supplemental reports to Vasquez's police report. Only defendants Rivera, Wells, and Tackard testified to seeing Plaintiff Miller carrying his supposed handgun. None of these defendant officers could offer proof besides visual assumptions that Plaintiff Miller was carrying a real firearm. Even though Miller represented it was rubber, he was not detained, no one asked to inspect it, and when he was instructed to put it away, he did. So after he committed the crime, after he gave probable cause that he committed a crime, I should say, then when he was instructed to put it away, he did. But there was already the probable cause that he had committed, past tense, a crime. He had walked into the building in violation of 3006 and 3007 with a firearm, or with what appeared to be a firearm. Probable cause. All the officers who interacted with him made sure to include in their reports they believed he was or received orders from someone who believed he was, that they believed he was or received orders from someone who believed he was a First Amendment auditor or Second Amendment auditor. So they believed he was. So they made sure to include in their reports they believed he, Miller, I'm assuming, was a First Amendment auditor or a Second Amendment auditor, or he received orders from someone who believed Miller was a First Amendment auditor or Second Amendment auditor. I don't understand why you would even include that. Additionally, Vasquez, Rivera, and Saucedo all described the Leon Valley Municipal Building, their multi-use city hall, in their reports as the Leon Valley Municipal Court. Well, it was court day. Why wouldn't they? I can understand the argument against it, but I could also understand why they would. Pronouncing Gloucester, Massachusetts, phonetically seems to really stir up the locals. What do they call it? Gloucester? Gloucester. Gloucester. I got a big old Gloucester in my pants. The building in question on that date also houses City Hall, Police Department, City Manager, and Animal Control. While the building include more than just a municipal court, including their own police station, defendant officers try to make it seem like the entire premises of the building belong to the court. Well, it was court day. Defendant King and Munoz, who, unlike Defendant Brooks, had not witnessed the events that occurred, worked together on the application for the warrants. Well, you know what? Most times, officers who are not involved, who are not actually percipient witnesses, most of the time it's officers who aren't percipient witnesses who apply for a warrant. Like, that's what happens. As neither detective had witnessed any of the events, Defendant King used Defendant Vasquez's police report and supplemental reports to complete an affidavit and submit it to the court with an arrest warrant and a search warrant. Okay. Defendant King and Munoz knew that Miller didn't break any laws. We have just established that King and Munoz were not percipient witnesses. So how could they know that Miller didn't break any laws? This is so fucking crap. I just want to stress how crap this is. All right, I'm going to start skipping through this. So he got the warrant. The warrants were signed off by a magistrate judge. Okay. He made his next move. What the warrants for? So to seize his evidence, a black semi-auto handgun, a GoPro camera, any cell phone media devices used to record, computer, desktop, or laptop, and photographic evidence. Okay, so that's what the warrant was for. Again, beliefs. Collect information. He organized a no-knock raid about 1 o'clock. Okay, came back at midnight 30. They decided with the garage door still open to be a good time to initiate the raid. Two Kirby officers entered Miller's garage and knocked on the inside door to his home. Campbell, hearing the knocks, informed Miller the knocks not sound friendly. Knocks, those sound like, why are you knocking on my door like a police officer? Worried about someone knocking on the door from the garage in the middle of the night, the plaintiffs approached with handguns in hand because, yeah, why not? When Miller opened the door, he saw a plaintiff and they set their handguns aside. Good. That's good. It's good that he didn't. They told him they had received a call about people breaking into his car and wanted to know if everything was all right. Believing their representations, bare-chested Miller joined the officers in the driveway to check his parked car. While he stood there, 10 officers carrying a veteran approached the house from the side, entered his garage, and entered his home. Weapons ready, even without a knock. Well, they'd already knocked. It's not a no-knock raid, you dumb fuckers, if the cops have already knocked. It's not a no-knock raid if the cops had already knocked. Ed asks, did the police find a rubber gun matching the description during the search? No, they did not. The defendant officer had not procured a no-knock warrant. That might be why they knocked. I'm just saying that whole knocking thing that sounded like a police knock, that was a knock. That was literally a fucking knock. I'm not even sure how to approach this any more than it was a fucking knock. I fucking knocked. Can I sue for emotional damage having to see this partially nude pic in the brief? Oh, there's better pictures of Miller out there. He likes to walk around in his underwear. Okay, so then they went in. Yep. Oh, look, here's a lineup. Light blue is an officer. That would be Andy Grigo. Green is a detective. That would be Terry Brooks with an AR, and Alex King with an AR. And not everybody had a body cam. Only one, two, maybe three people had body cams. Orange was sergeants. Okay. So Eddie Gonzalez and Tackard were sergeants. One had a pistol, the other one had a shotgun. All right. Anderson apparently was the lieutenant with a pistol, and Captain Saucedo had an AR. Nice. It looks like they were somewhat concerned that he might be. Oh no, yeah, they conducted a. Yep. Mm-hmm. Yep. They entered. Yep. No one was hurt though. Thanks for the picture of the kid, you fucking dipshits. Yep. Terrible kids are upset. Yep. Miller asks, "Are you Salvaggio?" A delighted defendant Salvaggio replied, "Absolutely." And when Miller swore, told him, "Welcome." And then when Miller swore, told him, "Welcome." Okay. Salvaggio then told Miller, "I remember you in your Bexar County days, actually, Jack." He's like, "I remember how much of a fuck up you were back then." Miller asked why he's being arrested. Salvaggio told him he's being arrested for bringing a prohibited weapon into a secured area today. Miller, who knew the so-called prohibited weapon was, so Miller knew it was a rubber prop gun, told Salvaggio the Leon Valley officers were a joke. Salvaggio responded, "No, and you're going to provide us all the evidence. That's a great part." So Miller said they're idiots. Salvaggio said, yes, we're idiots. But we're not sitting here in cuffs, Jack. That's the beauty of it. Salvaggio also told Plaintiff Miller, "So, Jack, you were beautiful today, and I appreciate you coming to visit us. This is awesome." When officers moved to take Miller out of his house to read him the search and arrest warrant, Salvaggio gloated, "That's the beauty of it, Jack. You're not in charge. That's the awesomeness." Defendant officers then moved Miller to his kitchen before eventually sitting him in a chair at the kitchen table where Miller could see his handcuffed family. Wow. I mean, he could see his handcuffed family. Oh, you know what? That's usually what happens. People get handcuffed during raids. I mean, I'm not saying it's good. That's usually what happens. I haven't seen anything unusual. So again, he says he was wearing a rubber Glock prop weapon, yada yada. So they moved him to the garage. Back outside, they summarized it. Arrest warrant because he came into the police department with a handgun. So they summarized it as police department. Great. Miller asks if they were he had a license to carry. That doesn't let you carry. One of them is you can't open carry. The other one is you can't concealed carry. 3006 and 3007. One is you can't open carry. The other one is you can't concealed carry. So they had a search warrant for the handgun he used the day before and the electrical devices used to record. Those items were to be collected as evidence. They had not informed they had obtained a search warrant for any computer or laptop. Well, if I remember correctly, it included computers and laptops, but okay. They didn't inform him. Whatever. They read him his Miranda rights, yada yada. The ransacking of his home. Yes, they have a search warrant. Guess what happens with a search warrant, kids? They fucking ransack your home. That's literally what happens with the search warrant. Now, the search warrant was for his house, right? So there are cameras. Okay. They found a gun safe in the hall closet. They broke it open. Well, I mean, they're literally looking for a firearm. One would expect them to search the gun safe, and they found the liquor storage in the gun safe. All right. Despite the limited number of items they requested from it had been granted permission to seize by the magistrate judge, they took whatever they wanted. They seized his Norinco rifle. So, if you find something that is or may be evidence of a crime while you're conducting a search warrant, the general rule mean, subject to various states' rulings on this, etc. Like if you're executing a search warrant for a firearm and you open up a drawer and you find a sack of cocaine, well, guess what? It's you were entitled to be doing the search because the firearm could have been in the drawer and you found the other thing. So finding the other things, I'm not sure that it's entirely unrealistic because, again, they point out that the painted black rubber Glock, that he had painted a rubber Glock. So they're looking for something that is black, but the complaint acknowledges that you could paint things. And so something that was painted black might no longer be black, and something that was black might be painted to be something other than black. And they missed the black painted rubber Glock that Plaintiff Miller had left in the glove compartment of his Lexus that night. The prop gun he had wore the day before, even though they searched the vehicle in front of Plaintiff Campbell. Well, congratulations. So they're bad at their job. Why are you painting rubber Glocks black, Miller? Why are you painting rubber Glocks black? So they took a rifle. They took this gun, which looks kind of black in this picture, doesn't it? Looks like a really dark gray. They might confuse that for the gun that he had on his hip. Might. I mean, did any of the people who had viewed the guns participate in the raid? You know, that's one thing that he's forgetting, is that the people who were there aren't on this little list of people who went in the raid. Anderson wasn't there. Brooks wasn't there. Gonzalez wasn't there. Tackard, I think, came after he had. Tackard was in the lobby after he had done it. Alonzo wasn't there. King wasn't there. Lehman wasn't there. Saucedo was in the lobby afterwards, and Grigo wasn't there. So none of these people saw the firearm. So, yeah, they're going to seize things that might be it. They also seized magazines. Well, now dude's arrested, so they're going to probably seize the firearms and they can come get them. Defendant officer also tried to take two other firearms, but Campbell insisted those firearms belonged to her, and so they left those weapons. Well, that's terrible. They had received permission to seize a GoPro camera, any cell phone media devices used to record, computer, desktop, or laptop, and photographic evidence. Had informed Plaintiff Bill they were only taking the electrical devices used the day before to record. Well, they'd informed of one thing, but then they seized a number of them. That's terrible. They had a warrant. All right. Well, anyway, I'm done with that. So this is the memorandum of opinion and order. This is by the district court judge who I initially, when I first read it, I'm like, holy shit, Justin Pulliam's a judge, but it's Jason Pulliam. Imagine that fat retard being a judge. That'd be terrible. All right, memorandum of opinion and order. Before the court is the parties' cross motions for summary judgment. The parties filed responses and replies after due consideration of the parties' briefings, the record evidence, and the applicable law. The court finds defendant officers are entitled to qualified immunity and therefore grants their motion for summary judgment on all accounts. The court accordingly denies plaintiff's motion for summary judgment and dismisses the case. The case is a 1983 lawsuit in which Miller and members of the family challenged the arrest and prosecution of Miller and the search of the family home, and blah, blah, blah. Oh, I guess I should read it because this is what the court found. In the early morning hours of June 1, 2018, officers executed a search and arrest warrant at Miller's home based on his alleged violation the day before of Texas Penal Code Section 4603 for bringing a firearm into a court or an office utilized by a court. Miller was indicted by a grand jury for the offenses, but the case was later dismissed. So the officers thought there was probable cause, the magistrate judge thought there was a probable cause, and the grand jury thought there was a probable cause. There's probable cause. Wow, it seems like, I'm just going to go out on a limb here. It seems like there's probable cause. I'm just going out on a limb. I mean, evidence would suggest that there was probable cause. Miller alleges the defendant officers violated the constitutional rights by retaliating against him for his protest activity. Miller's family members allege it's not that he brought something that looked like a firearm into a place that the officers believed was prohibited. It's not like that. It's for his protest activity that they retaliated against him. Miller's family members allege that the defendant officers violated their Fourth Amendment rights and executed an defective search warrant at their home. I assume that they're arguing it's defective because an officer who was not a percipient witness took witness statements to get the search warrant. Defendant officers argued they're entitled to qualified immunity because they had probable cause and believed Miller violated Texas Penal Code 4603. Miller's activism involves confronting government officials about purported violations of the law, often videotaping his interactions for publication on YouTube and Facebook under the handle TX Sheepdog72. See Defense Exhibit P, Deposition Testimony of Jack Miller. On May 31, 2018, Miller and a companion named David Howd visited Leon Valley Municipal Building, which houses, among other offices, the Leon Valley Municipal Court. Miller's stated purpose for visiting was to inform Leon Valley officials of his belief that the building signs prohibiting weapons were unlawful. Miller entered the building and encountered Officer Erica Rivera, who was stationed at the front door conducting security checks with a handheld metal detector wand. Miller asked Officer Rivera what types of offices were in the municipal building, and as she was listing offices, he interrupted her to ask if there was a court. She confirmed there was a court. Miller then explained he had come to register a complaint against the building's, in quotes, illegal, end quote, weapons prohibited sign. Officer Rivera asked Miller to step aside from the entrance, which he did, and said she would go find someone who would take his complaint. Officer Rivera walked into the building, around a reception desk, and into an internal waiting area where she began talking with Detective Wells. Miller, who could hear their conversation from the front entryway, stepped inside to poke his head around the corner. Ooh, this is what the court found. He stepped inside to poke his head around the corner and announced to Detective Wells that he was a person who asked to register a complaint. So he did enter further. That the court found. He entered further. Oopsie fucking doodles. Detective Wells approached Miller, and upon noticing a holstered weapon on Miller's hip, said, "Go ahead and step outside with your gun. It's a court day right now." Miller complied and stepped outside, at which point Detective Wells reiterated, "You're not going back in there. Court's being held." The two men exchanged words. That sounds like an argument. And Detective Wells eventually walked away, telling Miller to file his complaint with the Attorney General's office and refusing to engage further. Miller then briefly spoke with Lieutenant Anderson, who had stepped outside. Like Detective Wells, Lieutenant Anderson told Miller to file his complaint and refused to engage further. This is what the court found. Miller then turned to his companion, Howd, who was filming the interaction, and said, "Let me go put my gun up, and I'll go try it again." So he says, "Let me put my gun up. Not my prop, not my fake, my gun." Miller then placed his gun in the glove compartment of his car and returned to Leon Valley Municipal Building to file his complaint. At no point during his interactions with Officer Rivera, Detective Wells, and Lieutenant Anderson did Miller say that his holstered gun was a fake. Ooh. Indeed, in their depositions, all three officers testified they believed Miller was carrying an actual firearm. Video evidence depicts Miller openly carrying on his hip what appears to be a black handgun that is partially obstructed by a holster. Miller now says the gun was a fake rubber blue training gun that he spray painted black to make it look real. That's about the dumbest fucking thing he could have done. However, the court finds insufficient evidence in the record to support Miller's contention the gun he was carrying during his interaction with the defendant officers was fake, nor does it find evidence the defendant officers had reason to believe it was fake. Furthermore, the court finds Miller's entry into the building's lobby was sufficient to support the officers' reasonable belief that Miller had violated the statute. The court therefore finds the defendant officers are entitled to qualified immunity because they had probable cause to believe that Miller had violated Texas Penal Code Section 4603. Summary judgment is appropriate if the record shows there is no genuine dispute as to any material fact, and the movement is entitled to a judgment as a matter of law. A fact is material only if its resolution would affect the outcome of the action. Now, riddle me this, Batman. If facts are by definition true, why would you have to resolve it? It's already true. A genuine dispute for trial exists if the record taken as a whole would lead a reasonable trier of fact to find for the non-moving party. Because there must be a genuine dispute of material fact, the mere existence of some alleged factual dispute between the parties will not defeat an otherwise properly supported motion for summary judgment. The moving party bears the initial burden of informing the court of the basis for the motion and of identifying those portions of the record which demonstrate the absence of a genuine dispute of material fact or the appropriateness of a judgment as a matter of law. Furthermore, when the movement asserts a qualified immunity defense, that assertion alters the usual summary judgment burden of proof. In the context of summary judgment, government employees only need to assert the defense in good faith. They have no burden, quote, to put forth evidence to meet their summary judgment burden for a claim of immunity, end quote. Once a government employee invokes qualified immunity, the burden shifts to the plaintiff to demonstrate the inapplicability of the defense. The plaintiff must rebut the defense by establishing a genuine factual dispute as to whether the allegedly wrongful conduct violated clearly established law. Upon the shifting burden, unsubstantiated assertions, improbable inferences, and unsupported speculation, like people's motives, are not sufficient to defeat a motion for summary judgment. The party opposing summary judgment is required to identify specific evidence in the record and to articulate the precise manner in which this evidence raises a genuine dispute of material facts. Further, should the non-moving party fail to address or respond to a fact raised by the moving party and supported by evidence, the court may consider that fact as undisputed. And such undisputed facts may form the basis for a summary judgment. In determining the merits of a motion for summary judgment, a court has no duty to search the record for material facts or to find a party's ill-cited evidence. In addition, a court may not make credibility determinations or weigh evidence and must view all evidence and draw all reasonable inferences in the light most favorable to the party opposing the motion. When versions of events differ, the court is required to view the facts and draw reasonable inferences in the light most favorable to the party opposing the summary judgment motion. In qualified immunity cases, this usually means adopting the plaintiff's version of facts. However, the court is not required to credit the plaintiff's version when that version is contradicted by unambiguous video evidence. Instead, it should view the facts in the light depicted by the videotape. While a court may not ordinarily weigh credibility in summary judgment, it may assign greater weight to facts evident from the video recordings taken at the scene. Applicable law, Section 1983, qualified immunity, Frank's liability, retaliatory prosecution, discussion. All right. This case centers around Second Amendment activist Jack Miller's May 31st, 2018 protest activity. The court determines its protest activity. That's crazy. At the Leon Valley Municipal Building and defendant officers resulting search, arrest, and prosecution of Miller for violating Texas Penal Code Section 4603. Miller's companion at the Leon Valley Municipal Building, David Howard, is not a party to the case, but is noteworthy because he recorded Miller's protest activity that day and discussed events with Miller on camera as they were unfolding. The remaining plaintiffs are Miller's family members who were present on June 1, 2018, when officers executed a search warrant at their home. The defendant officers argue Miller's family members should be dismissed because they abandoned their excessive force, malicious prosecution, and failure to intervene claims. While it is true that Miller's family members cannot assert claims based on violations of Miller's civil rights, they can claim their own rights were violated by a defective search warrant. The court therefore addresses Miller's family members' claims in its analysis of the search warrant's validity. The parties disagree as to which defendant officers are still the case. Plaintiffs originally named Salvaggio, Wells, Anderson, Saucedo, Vasquez, and State Police Officer Doe. Plaintiffs then attempted to add officers Grigio, Tackard, and Gonzalez, but later voluntarily dismissed them for lack of service. Defendants further argued that officers Brooks, King, Munoz, and Rivera should be dismissed because they were added after the statute of limitations expired Indeed, the statute of limitations is 2 years, and officers Brooks, King, Munoz, and Rivera were added to the complaint more than 2 years and 3 months after the events which gave rise to the lawsuit. Defendants correctly note that changing defendant officers from Doe to a named individual does not qualify as a mistake, allowing the amendment to relate back to the original complaint. While the court finds this argument compelling, it does not need to dismiss defendant officers on this theory because it finds that they're entitled to qualified immunity. Based on the record evidence, the officers whose activities are most relevant to the court's analysis are Sergeant Gonzalez and Detective King, who worked together on the probable cause affidavits for the arrest and search warrants. Officer Rivera, who's working security when Miller entered the Leon Valley Municipal Building, and Detective Wells and Anderson, who interacted with Miller while he was still wearing his holstered gun. Plaintiff's third amended complaint, which is the live pleading, brings 8 counts against defendant officers. Prior to the dispositive motion deadline, plaintiffs voluntarily dismissed 3 counts. The remaining counts are retaliatory arrest, unlawful entry, unlawful search, and retaliatory prosecution. To succeed on their claims related to Miller's arrest and search of his home under counts 1, 2, 3, and 4, plaintiffs must overcome the defendant officer's good faith showing of probable cause. To succeed on the retaliatory prosecution claim, count 7, plaintiffs must plead and prove the absence of probable cause for the underlying criminal charge. The dispositive motions on all remaining counts, therefore, is whether the defendant officers had probable cause to believe Miller violated Texas Penal Code Section 4603. Probable cause is a practical, non-technical conception that deals with the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. It turns on the assessment of probabilities in particular factual contexts, not readily or even usefully reduced to a neat set of legal rules. Instead, courts must look to the totality of the circumstances and decide whether these historical facts, viewed from the standpoint of an objectively reasonable officer, demonstrate a probability or substantial chance of criminal activity. But while probable cause is not a high bar, the belief of guilt must be particularized with respect to the person to be searched or seized. Section 4603 of the Texas Penal Code provides that a person commits an offense if the person intentionally, knowingly, or recklessly possesses or goes with a firearm on the premises of any government court or offices utilized by a court. Section 4601, subsection 3, defines a firearm as any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. 4603C4 defines premises as a building or portion of a building. It further notes that the term does not include any public or private driveway, street, sidewalk, or walkway, parking lot, parking garage, or other parking area. Plaintiffs proffer 3 theories upon which they say the court should find defendant officers lack probable cause to believe that Miller violated Texas Penal Code Section 4603. First, they say Miller was carrying a fake weapon when he entered the Leon Valley Municipal Building on May 31st, 2018, and therefore he did not have a firearm in violation of Texas Penal Code Section 4603. Second, they say because Miller stayed near the front entryway to the municipal building after encountering Rivera at the security desk, he was never on the, quote, premises, end quote, of a court or its offices in violation of Texas Penal Code Section 4603. Finally, plaintiffs argued that because the Leon Valley Municipal Building is used for multiple government functions, it is not a court or offices utilized by a court under Texas Penal Code Section 4603. The court considers each of these arguments in turn. The firearm. Plaintiffs argued that Miller did not violate Texas Penal Code Section 4603 because he was not carrying a firearm within the definition of the statute. I'm going to go ahead and just project here that it doesn't matter whether he was or wasn't violating the law. That's not what they have to prove. They have to prove whether or not there was probable cause. They say the gun Miller brought into the building was a fake rubber blue training gun that Miller spray painted black. Miller offers no evidence the gun he wore during his encounter with officers was fake other than his, quote, unsubstantiated assertions, end quote, which are insufficient evidence to overcome a summary judgment challenge. What his testimony makes clear, however, is that even if the gun was fake, he painted it black so people would think it was real. When asked, so you actually painted that blue gun black so it would look like a Glock? Miller responded, quote, no criminal or bad dude out there is going to believe it's real if it's blue. So yeah, end quote. Miller is a fucking genius. Jesus. GED Jack. Oh, Christ on a cracker. If the gun was fake, Miller successfully tricked the defendant officers into thinking it was real. All the officers who interacted with Miller when he first entered the Leon Valley Municipal Building Rivera, Wells, and Anderson testified they believed Miller was carrying an actual firearm. While their deposition testimony provides some evidence of the officer's subjective belief the gun was real, the court assigns greater weight to, quote, facts evident from the video recordings taken at the scene and handily provided to the court in the complaint that shows Miller carrying something that looks really, really fucking suspiciously like a pistol on his hip. Here, video evidence depicts Miller openly carrying on his hip what appears to be a black handgun that is partially obstructed by a holster. The video evidence is not sufficient to determine whether the gun is real. However, it is sufficient to establish the defendant officers were objectively reasonable in so believing. Furthermore, the video evidence shows that at no point during his interactions with the officers did Miller say his holstered gun was fake. To the contrary, Miller made statements suggesting the gun was real. For instance, when Detective Wells told Miller to step outside with his gun, Miller complied and did not say anything about the gun being fake. To the contrary, once the men were outside and Detective Wells restated that Miller could not enter the building with a gun, Miller started arguing with Wells about repeating himself, saying, "I heard you when you said to get out with the gun." That would have been an opportune time for Miller to tell Wells the gun was fake, but he never did so. Instead, after Wells left, Miller had a brief conversation with Anderson and then turned to Howard and said he was going to put his gun in the car, again referring to it as a gun and not as a fake gun. Plaintiffs argue the defendant officer should have searched Miller on the scene to determine if the gun was real or if they believed he had violated Texas Penal Code Section 4603, arrested him on the spot, which is a really fucking stupid argument to make. But officers had no reason to believe the gun was fake, and Anderson later testified he decided to obtain a warrant before arresting Miller to avoid confrontation. Yes, blah, blah, blah is a legal term in Black's Law Dictionary, MERB edition, along with oopsie doodle and peeky poo. Exactly. I'm glad I can educate my audience. When you get done with this series on learning legal terminology, you will be able to pass as a 20-year internet constitutional law scholar in front of anyone with flying colors. Plaintiffs allege Miller announced the gun was fake loud enough for officers to hear, but the video evidence does not support that assertion. After Miller put his gun in his car, he returned to the municipal building to file a complaint. While Miller was filling out his complaint in the reception area, Howard told Miller they were being, quote, stared down, end quote, by officers on the other side of the glass window. Miller responded he had received a text message saying that Leon Valley officers were talking internally about whether they could arrest him for bringing a gun into the building. Miller then said to Howard, "I'll let him arrest me, go out to the car and retrieve the gun, and they're going to find out it's a rubber gun. They can take the handcuffs and maybe then they'll talk." The court takes no position on whether Miller's statements about the text message of the rubber gun were true. However, they do offer evidence of Miller's subjective belief that the officers thought the gun he was carrying was real. So his own fucking testimony gives evidence that he thought at the time the officers thought the gun was real. Further, there's no evidence the officers heard Miller's statement to Howard about the gun being fake. Though there were officers nearby, Miller was not addressing them directly. Miller was talking to Howard in a conventional tone in a busy reception area full of other people and background noises. Plaintiffs argued the gun recovered at Miller's home, a black and silver Glock, could not have been the gun holstered on Miller's hip at the Leon Valley Municipal Building, which appears to be all black. They further point to Officer Rivera's testimony the black and silver Glock that was recovered was not the same gun she saw Miller wearing. While this detail is some evidence the gun recovered at Miller's home was not the gun he wore at the Leon Valley Municipal Building, it does not rule out the possibility he was wearing a different, real gun. I don't even think it rules out the possibility that that was the gun that he was wearing at the municipal building, because you could have had an extra slide. He could have painted the slide or had an extra slide, because Glocks have interchangeable parts, and he might have had a black slide. You never know. You never fucking know. Therefore, the plaintiffs do not present evidence which raises a genuine dispute of material fact to undermine the officers' belief the gun was real. The video evidence of the encounter unambiguously shows the officers were reasonable in believing Miller was carrying a real gun at the Leon Valley Municipal Building. Unambiguously shows the officers were reasonable in believing Miller was carrying a real gun Plaintiffs further assert that in executing the search warrant, officers neglected to take into evidence a fake rubber gun that was left in the glove compartment of Miller's car. Here again, plaintiffs rely on Miller's, quote, unsubstantiated assertions, end quote, which are insufficient evidence to overcome a summary judgment challenge. That being said, the mere existence of a rubber gun does not establish it was the gun Miller was carrying at the Leon Valley Municipal Building, nor does it create a fact issue, as to the officer's reasonable belief the gun was real. After considering the totality of the circumstances, the court finds Miller has not presented any evidence that the officers had reason to believe he was carrying a fake gun. To establish Frank's liability, the legally relevant question is not whether Miller was carrying a real gun, but rather whether the defendant officers, quote, knowingly and intentionally or with reckless disregard of the truth, end quote, falsely stated Miller was wearing a real gun. Because the court finds no evidence the defendant officers made such false statements, plaintiff's challenge to the arrest and search warrant affidavits based on the officer's characterization of the gun fails. Likewise, plaintiff's retaliatory prosecution claim fails because officers established probable cause for the underlying criminal charge based on their objectively reasonable belief the gun was real. The court finds defendants did not violate plaintiff's constitutional rights regarding these claims. Premises. Plaintiffs argue that because Miller stayed near the front entryway of the Leon Valley Municipal Building after encountering Rivera at the security desk, he was never on the, quote, premises, end quote, of a court or its offices in violation of Texas Penal Code 4603. 4603 C4 defines premises as a building or portion of a building. It further notes that it does not include any private or public driveway, street, sidewalk, or walkway, parking lot, garage, or other parking areas. The video evidence conclusively establishes that Miller entered the Leon Valley Municipal Building through two sets of doors past signs saying weapons were prohibited before encountering Rivera at security. He did comply with Officer Rivera's request to step to the side and wait while she went to find someone to take his complaint. However, at that point, Miller was already on the premises within the meaning of the statute. He was in the building as distinguished from an outside driveway, street, sidewalk, parking lot, etc. Furthermore, when Officer Rivera was talking to Detective Wells, Miller stepped further into the building to announce he was the person who came to register a complaint. The court, therefore, finds conclusive evidence to establish that Miller was inside the building, sufficient to give rise to Texas Penal Code Section 4603, liability, and plaintiff's premises argument fails. Number 3, the court and its offices. Finally, plaintiffs argue that because the Leon Valley Municipal Building is used for multiple government functions, it is not a court or office utilized by the court subject to Texas Code Penal Section 4603. Here, plaintiffs invite the court to engage in statutory interpretation to answer the question Miller raised when he visited the Leon Valley Municipal Building on May 31st, 2018. According to plaintiffs' interpretations of the law, the portions of the Leon Valley Municipal Building that are not used by the Leon Valley Municipal Court are not subject to Texas Code Penal Section 4603, and weapons are therefore not prohibited. The court need not answer that question, however, because a legally relevant question in this case is whether the defendant officers were reasonable in believing Texas Penal Code Section 4603 applied to the Leon Valley Municipal Building. The officer's reasonable belief was established by undisputed video evidence showing signs posted outside the building saying weapons were prohibited. Furthermore, the officer's belief was validated when the magistrate judge signed the arrest and search warrants and the grand jury returned an indictment charging Miller with violating Texas Penal Code Section 4603 by bringing a weapon into the Leon Valley Municipal Building. Plaintiff's statutory argument, therefore, fails. If everybody's interpreting it the same way, the officers aren't unreasonable for doing the same thing. Conclusion. In conclusion, the court finds defendant officers have probable cause to believe Miller violated Texas Code Section Penal Code 4603. Because plaintiffs failed to create a genuine dispute of material facts as to the defendant officer's good faith showing of probable cause, their claims related to his arrest and search of his home under counts 1, 2, 3, and 4 fail. Likewise, because plaintiffs failed to plead and prove the absence of probable cause for Miller's underlying criminal charge, the retaliatory prosecution claim under count 7 fails. Plaintiffs failed to establish a genuine factual dispute as to whether the defendant officers violated clearly established law. Specifically, the court finds insufficient summary judgment evidence to support plaintiff's suggestion on the first prong of the qualified immunity analysis that defendant officers violated a statutory or constitutional right. That finding necessarily leads to the conclusion of the second prong that the defendant officers' actions did not violate a clearly established statutory or constitutional right of which a reasonable person would have known. So they failed on the harder of the two tests. So there you go. And then finally, this is a short one. This is only 4 pages. So, and the 4th page is very short. The plaintiff's attorney has filed a motion. It's a motion to reconsider. It's the same thing. So they move the court under Rule 59E to amend its judgment, alter or amend its judgment. Plaintiffs assert the judgment was based on a manifest error of law or fact. They're like, hey, court, you fucked up, and we really want you to amend your judgment because you fucked up. Now, this is 99 times out of 100 a failing strategy, but it will give rise to an appeal. Well, it could. They don't technically have to appeal. I'm not entirely sure they should appeal, but whatever. First, this court mistakenly asserted the plaintiff could only prevail on count 4, unlawful search, if they overcome defendant officer's good faith showing of probable cause. This disregards plaintiff's claim that the defendant seized firearms, mobile phones, and other electronics that weren't identified in the scope of the warrant. Mobile phones were identified in the scope of the warrant. The other electronics were, except for the router, but the router would have evidence of devices it connected. So I can see why they would seize the router. Second, probable cause could not have existed to obtain a search warrant of Jack Miller's residence. Why not? Wouldn't that be where they'd find the firearm? And the videotape evidence, or the recording evidence that Jack Miller had of him carrying the firearm? The officers, Captain Khan says, seems like a DeCastro move to me. It's not an unreasonable move to make. This particular attorney has spent a lot of time and money chasing this particular case and probably wants to get paid. And this 4 pages of briefing to maybe get the court to reconsider, maybe. I mean, it's not impossible that the court will reconsider. It's just highly unlikely. The courts did not provide, or the officers did not provide any facts whatsoever that linked any evidence of any crime to Jack Miller's residence. Well, Jack Miller lived there, and Jack Miller had a firearm and may have photographic or video evidence of him committing the crime there, because that's where Jack lives. I mean, is this too disconnected? I don't think so. The officers never detained him at the multi-use building and allowed him to get his vehicle and drive away. You've made that argument already in your complaint. That didn't work. No one followed him. Well, again, you said they ran his plate, so did they not follow him? But did they have to follow him? Again, it doesn't really help you. How could the officers assert Jack Miller's residence would have evidence of the crime? Well, it's based on probable cause. The warrant will issue on probable cause, not so. They've already shown that Jack Miller probably committed a crime. The grand jury agrees he probably committed a crime. The magistrate judge agreed he probably committed a crime. Now, where would the evidence of that crime lie? Well, evidence of the crime would be, number one, the firearm. Where is the firearm probably? Well, it's probably at Jack Miller's home, because it's Jack Miller's firearm, right? Probably there. Where would video evidence of it be? Probably at Jack Miller's home, because that's where Jack Miller is. Where would photographic evidence be? Well, probably at Jack Miller's home. This is a shit argument so far. Of course, these extra details were omitted from the search warrant affidavit. Well, I haven't seen the search warrant affidavit, but if I told a judge that I wanted to search somebody's home based on or looking for a firearm that he used to commit a crime and any photographic or video evidence of that crime that he took because he's an auditor and he was recording shit, the court's probably going to be like, yeah, okay. And like, what else do you have to put in there? A valid search warrant may only be issued on a finding of probable cause, and the information necessary to show probable cause must be contained within a written affidavit under oath. Yeah, there was no problem with the search warrant. The police officer seeking the issuance of a warrant must present an affidavit containing facts sufficient to provide to the magistrate a substantial basis for determining the existence of probable cause. Yeah, Jack Miller carried a firearm into a public building. We saw him carry a firearm into a public building that housed a court in violation of Texas Penal Code 4603. So we want a warrant to get the firearm and any photographic and video evidence of it from Jack Miller's home. Qualified immunity does not protect officers who maliciously or recklessly represent or omit material information when presenting information to procure a warrant or indictment. Third, probable cause could not have existed at the time the officers drafted the affidavit and submitted it to the magistrate. Why not? Specific to the weapons prohibited charge, the conduct prohibited is possession. Yes, they have video evidence of him possessing something that appears to be a firearm inside the prohibited premises. The offense of possession of a prohibited weapon is complete when a person is placed in possession of the prohibited weapon. There's no question the officers did not know with any certainty whether Jack Miller possessed a prohibited weapon in a prohibited place. They only needed probable cause. Probable cause. However, once the defendant officers allowed Jack Miller to leave the building and drive away, objectively, every reasonable officer would understand that they could never establish later whether Jack Miller possessed a prohibited weapon. The court literally just found that there was probable cause. This court, in this case, just found there was probable cause that Jack Miller possessed a real, actual firearm. They definitely could prove it. Like, I don't know if this guy doesn't do any criminal law, but they could definitely prove it. They could definitely prove it beyond a reasonable doubt. I mean, they didn't in this particular case, but you can definitely prove things subsequently. That is literally a reason for search warrants. That's the reason for search warrants. If search warrants would not allow you to find the evidence that would prove beyond a reasonable doubt that someone committed a crime, then we wouldn't issue search warrants. No matter how many firearms they found in his home or strapped to his hips. No, they could. I mean, they have pretty good pictures of the firearm. They could match up the visible parts of it enough that a juror could find beyond a reasonable doubt. Because remember, it's not no, it's but believe beyond a reasonable doubt. It has to be a reasonable doubt, not a shadow of a doubt, but a reasonable doubt. Nonetheless, the officers omitted critical information in the arrest warrant affidavit, which they knew would mislead the magistrate to believe they knew with certainty that Jack Miller possessed a prohibited weapon in a prohibited place, and there was certainty that they would recover that specific firearm. No, they would have said that they have probable cause to believe that Jack Miller possessed a prohibited weapon in a prohibited place, and that there was probable cause they would recover that specific firearm. Specifically, they represented Jack Miller, in fact, had a firearm. If the officers represented they thought it was a firearm, this would have raised objections or raised objective questions about whether they could ever establish the crime once they allowed him to leave twice and drive away. No, it wouldn't. No, it wouldn't. Just match up the firearm to the video recording. They omitted they never detained Jack Miller. Well, they omitted that they never detained Jack Miller. But you know what they didn't do? They didn't insert that they had detained Jack Miller. Normally you have to state the things that you did, not the things that you didn't do, because the list of the things you didn't do is almost infinite. The things that you did is a much shorter list, a more finite list. They omitted that he returned to the lobby to file his complaint and that they had ample time to detain him. Why would that change whether or not they had probable cause? That doesn't change anything. They admitted they never accused him of violating the law or that they did not know who he was until Salvaggio told them after Jack Miller left. Again, number one, how does that affect probable cause? And number two, did we forget he introduced himself? Did we forget that they had someone run his plates? Did we forget that he turned over a complaint form that had his information on it? The officers admitted that he drove away and no one followed him. Again, Again, what they didn't do is an infinite list. As previously stated, qualified immunity does not protect officers who maliciously or recklessly represent or omit material information. Is it material that they didn't follow? No. Is it material that they didn't detain him? No. What is material? What is material is, did they have probable cause to believe he had committed a crime? They saw something that looked like a firearm that he in no way disabused them of believing was a firearm on his hip in a place that was prohibited for the possession of firearms. He possessed a firearm or something that they thought was a firearm in a place that they thought was prohibited to possess firearms. Fourth, even if probable cause did exist, which it fucking did, I mean, we've had the police think it was probable cause. We had the prosecutor who filed charges believe there was probable cause. We had the grand jury believe there was probable cause. We had the magistrate judge believe there was probable cause. And we had this court believe there was probable cause. I'm going to go out on a fucking limb that there was probable cause. I think there was probable cause. Then the court should evaluate whether the Neves versus Bartlett exception applies for the retaliation claims. Well, you should really lay it out. There is objective evidence in the summary judgment record detailing that Leon Valley police officers would treated Jack Miller differently from any other citizen once they realized who he was. Well, they were treating him without knowing who he was until they knew who he was. Right? And they didn't know who he was, according to the complaint, until Jack Miller introduced himself. That's after he's already been allowed to go return the firearm or firearm replica to his car and return to do a complaint. There were already, like, he could have left instead of returning his firearm to his car. He could have gotten in his car and left at that point. So what makes him believe that they treated him any different than anyone else? Because until they knew who he was, they were treating him exactly like they didn't know who he was. Until they knew who he was, they were treating him, by definition, like someone who they didn't know who he was. A better saying, says GMK, a better saying is a ham sandwich gives rise to probable cause. The actual saying is something along the lines of you can indict a ham sandwich because of how low the probable cause standard is. And yes, it is a low burden of proof. And that low burden of proof is a problem for the plaintiff in this particular case because it is such a low burden of proof, and the officers had it. They literally had probable cause. It's a low burden of proof. Specifically, Officer Rivera testified that when people came to her security table with a prohibited item, they were to be offered a lockbox and allowed entry. Well, again, when Miller came to Rivera's table, she didn't offer him. She didn't know who he was, and she didn't offer him a lockbox. She never prepared any incident report or arrested anyone. Well, she didn't prepare one, but she is the one who was the eyewitness that the other officer took the eyewitness testimony of and turned it into a police report. So while she didn't prepare an incident report, another officer did prepare a police report that used her eyewitness testimony. Jack Miller was treated differently for his activism and because he was filing a complaint against the city of Leon Valley. I see it kind of differently. I see it as they gave him like an extra opportunity because he said he wanted to file a complaint. Rivera went to get someone to like see what we could do, and then they ended up allowing him to go in and file a complaint. For these reasons, plaintiffs respectfully request this motion be granted and the court's order and judgment vacated and summary judgment granted to plaintiffs in this matter. Well, good fucking luck. Good fucking luck, Brandon J. Grable. Good fucking luck. Swing and a miss there. All right. Ed asks if you can indict a ham and cheese sandwich. I've never tried it. I've never worked for the prosecution. Respect Earn says his complaint does show how dumb he is, and the lack of any knowledge of police procedures, like search warrant and execution of it, or what's cover or not under such warrant. Well, I don't, I don't know if this Brandon Grable has done criminal law. Civil litigation, civil rights. He does criminal defense. So, I don't know. I'm not saying he's a bad attorney. His complaints suck ass. His complaints suck serious ass. Fuck this guy's complaints. They suck. Your complaints suck, Mr. Grable. Sue me for defamation. Your complaints suck ass. God. But I don't know that Mr. Grable is dumb. I would not say he's dumb. Uh, yeah, I wouldn't say he's dumb. I haven't seen anything to suggest that he's dumb. I mean, so, one of the unfortunate things about being an attorney is you don't get to pick the facts. You don't get to pick the facts. And sometimes you get a shit set of facts. And you got to do what you can do with a shit set of facts. And I think Mr. Grable is kicking himself that he didn't get a mediated settlement, because that would have been his out, because he had a shit case. He had a shit case. I'm not saying that that Leon Valley was right to do what they did. I'm not saying that Miller was wrong to do what he did, but I am saying that the police in his case, the Leon Valley police, had probable cause. It's evident from the complaint itself. Uh, it, he had a shit case, and he inherited this one from Radner. Radner likes to file shit cases. Um, Radner's one of those guys who he's a quantity over quality guy. You have like 15 to 20 of these cases going at any given time. You're going to get payouts at any given time. So, GMK says Swiss, yes. Sharp cheddar, no. Too sharp. Good point. Pat's Cat says, I hear that grand juries do all the time. I don't know about all the time. And, it's kind of insulting to grand juries to suggest that they're somehow stupid, because they're made up of people. People are stupid, honestly. So I guess that is a problem. But the real issue is that only the prosecution gets to present evidence in a grand jury. So they hear one side of the argument. Usually convince people pretty easy off one side of the argument. Pat's Cat says, but I love sharp. I know sharp cheddar cheese is the best. Well, it's not the best, but it's really good. I really like aged Gouda with the little crystals, the little protein crystals it gets. I love me some aged cheese. Ed says, wouldn't you have to show that people who weren't activists were allowed to enter with firearms to prove Jack was treated differently because of his activism? Not necessarily. Not necessarily. But it would help. It sure would help. It would go a long way. And then a thumbs up from Ed. I'm not sure. I'll go back up a little bit, I guess. I'll read some from the start. We don't get to the start, I guess. Maybe this is. Hold on. How do we do this? And then we can do this. And then, all right. So Darcy says, yup. Internet God says, I didn't think you'd gone kid friendly. I'm certainly not. Bandit says hello. Vixter says chat. Nima says hey. Scott Amo says hellos. Brian the Bard says hello. Paul Berry asks which stun scap is Salvaggio. He was the police chief for Leon Valley. And he fucked up royally and got away with it for the arrest of all the people who are protesting. That was bullshit. I still think he got away with that. That was fucked up. Denise Lynn says, was in jail for a long time. Bao was in jail for a long time. Burns says, smiley face. Cheeky Monkey says, audio's a bit low. Or adios, a bit low. Burns says, lol, I used to say Bexar County. It is Bexar County. Darkly Noon says, Merv trolling his fans with kid mode on. Oh, that was bad. I'm sorry. Did not mean to do that. Captain 3D says, audio is great. Nice. Paul Berry says, just read the background. Salvaggio is no longer chief for reasons other than what Miller claims. Okay. I think he was fired, but I don't know. I don't know the background behind it. It'd be interesting to find out the background behind it. Taze Otter says audio is way too loud. Dave Wright says volume is a touch on the low side. This is what I have to deal with. Fuck y'all. Fuck all y'all. Burns says, I actually lived there. Lowell had justly duty one time. Jury duty, maybe? It was crazy because the guy defending himself went pro se. Usually, if a guy is defending himself, that means he's pro se or pro per, depending on however. I think in Texas they call it pro per. Burns says, thanks for the warning. Burns says your volume is fine. Denise Lynn says, wasn't Jack an ex-cop? He was a ex-deputy sheriff who worked the prison. Burns says there was no issue with the volume when I came in. BioExplorer says poor Merv just can't win. Really, it sounds exactly the same to me, and it sounds fine. Burns says, Lord, my spelling has been atrocious the past few days. Just the past few days? We're giving ourselves a little too much credit. WTT says, I thought he was jailer. Oh, yeah, they use the deputy sheriffs as jailers. Denise Lynn says, no, he was hurt from what I heard, but then again, everybody lies. I didn't say he got fired, but my understanding is that he quit in lieu of being fired. That's my understanding. Now, take it with a grain of salt. I have had a few people represent to me that they were in law enforcement in Texas, in who would have reason to know the surrounding story, and they were all fairly closed about it, other than to say he's a terrible dude and he's never going to get rehired, and he would have been fired if he had not otherwise exited the scene. Burns says, dang, this is all in my neighborhood. It's all in my hood. His auditors laugh like hell, says WTT. How much money have you put on Earl's books? Probably none, because you don't get the joke, Taze auditors. You don't understand the situation. Burns says there are signs like that in every state building. Okay. The BioExplorer says in most jails, the quote jailers, end quote, are still sworn officers. WTT says at Taze auditors, only the money your mom has given me for services rendered. He's just a gigolo. And everywhere he goes, people know the song he's singing. Captain Clown says, I am going to go with that being a terrible idea. Okay. Mike's brown paper bag says, will you represent me in a suit against a man who puts his bottles in me? I don't know who that is a troll against, to be honest with you, Mike. Sorry. Days Otter says, that's a fortune, WTT. Oof. 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 I like it. I like your sense of humor, Taze. Denise Lynn says, I know it was years ago, but isn't that when he had the pink vibrator? He did have a pink vibrator. Orange Cone says, do you ever sleep? Lol. I do. I do. Rarely. WTT says, at Denise Lynn, don't act like you don't have a pink one as well. She's probably got all sorts of different colors and all sorts of different sizes. Burns says, I don't understand why people need to open carry. It's an invitation for trouble. I kind of agree with you. I think it's better to concealed carry. If you open carry, people might grab at it or something. Concealed carry, I think, is a little bit safer, but I'm dumb and I'm probably wrong. Denise Lynn says, nope, purple, among others. Captain Clown says, laughing faces. Taze Otter says Watt's vibrator is rainbow colored. I think he means WTTs. Mike's brown paper bag asks Orange Cones, did they ever catch the guy in Ironton? WTT says Denise Lynn, lack of circulation will turn one that color. Purple headed warrior. The Bio Explorer says at Burns 66 agreed. Concealed seems better all the way around. Devin E says, hey there, Merb and chat. Taze Otter says WTTs. Burns says, funny how the city of San Antonio surrounds Leon Valley. Is that funny? Funny haha. Denise Lynn says, WTT, you would know, hun, kissy face. Burns says, at the Bio Explorer, especially when there are people out there who are willing to do anything to get their hands on one. That's true. Bio Explorer says, seriously, I don't want to go shopping in a store that is in a town where people open carry. Well, you know, I've been in Arizona, in a town where people open carry, and everybody was open carrying, and it wasn't a big deal because it was just what you do. And I've been in Montana where people were open carry. I don't know if they do that all year long or if they were doing it just for the hunting season, but they were just open carrying, and it wasn't a big deal. In places where it's uncommon to open carry, then yeah, I mean, it sticks out like an eyesore. It attracts attention. Captain Clown says, last time I checked telepathy, real or imagined, was not admissible in court. It's really hard to get something like that into court. You know, there's that whole lack of foundation kind of thing. And God says not allowed to carry a gun at all anymore in New Mexico. I believe it's for 30 days. You can't carry a gun, I believe, is what I saw. I don't know really what's going on about that. WTT says only one county. Yeah, I think it's like Albuquerque, right? Vern says New Mexico is beautiful. Love taking trips there. Yeah, it is a beautiful place. Love the sunrise. I drove through there when those mesas, they're bright red and there was still some green popping up around them. It was beautiful sunrise in New Mexico. The air was clean. Burn says no, that looks real. Burn says that gun looks real. Yep. Bioexplorer says the rooster demands his few minutes of on-air time in exchange for video being shot in his yard. Probably. GMK says just end firearms inside any building. No, your home is a building. Well, unless you're chilly, then your home is like a van or something like that. Captain Clown says I'm old enough to remember when there was a shotgun disguised as a super soaker that had been recovered by the police. Yeah. Bioexplorer says the picture actually makes it look like it was reasonable to not know it was real or fake. Yeah, I know. Laughy faces. Orange Cone says, add Mike Brown, paper bag. Ironton manhunt still ongoing. Burn says, that was freaking loud, lol. Bird says, ha 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 ha. Someone is freaking loud. Orange Cone says, message retracted. I believe, if I remember correctly, Orange Cone had asked, does Inigo have his own mic? Captain Collins says, Fabio is clearly expressing his First Amendment rights. That is true. I don't know if chickens or roosters have rights, but if he did, he would be exercising them. Orange Cones then correctly states, does Fabio have his own mic? No, he does not. He's just loud. BioExplorer says, being a graduate of the University of South Carolina, I must support my school's mascot. Throw away, dude. Well, they will. Burns says, why would anyone do that? Paint a training gun black and carry it in a state building because he wants to get arrest support, clicks and views, etc. He thinks he's smarter than he is. Nasty Nate says, very unimaginatively, that I am a fascinating man. But he says that about a lot of people. And so it doesn't really mean anything. It's overused, Nate. Just saying. Burns says, I don't get why people do the stuff they do. I also don't. The BioExplorer says, exactly. They also have to determine how to handle it so that they don't have 10 more of him doing it next week. Yes, that is true. Captain Clown says, how, or, the call floods. I'm going to call flood. They probably don't want all that bullshit. They probably don't want it. Not that it affects them specifically, but it causes problems, so they probably don't want to do it. Captain Clown says, how dare the police use their discretion and good sense in dealing with an obvious frauditor? Well, I mean, I'm not saying that Miller's interpretation of those particular sections is unreasonable. So, do with that as you will. I'm not calling him a frauditor, at least not on this particular situation. Laura asks, how does he know what they said were thinking and, quote, scattered, trying to act casual, end quote. Did he get body cam footage of each defendant or something? He probably got some video of them. Some of it he probably made up. And the third amended complaint was pretty late. So, so the third amended complaint was in October. The summons, amended complaint. So they had the pretrial conference already. They might have already done. There's a rule discovery report on August 10th. So they had probably already done some discovery August 10th, and then down here October. So they had a month. So they would have already had like initial disclosures done and everything like that. Well, presumably they would have had initial disclosures done. So there might have been something in there showing it. The bioexplorer says he could have gone to his car to get a printed gun that wouldn't set off the metal detector and bring one in anyway, possibly. Diz Dukes asks a question: why do you go to family law? Why did you go to family law and not constitutional law in your profession? Just curious. I hate to. Oh shit! You couldn't see anything. I was blocking the entire thing. Anyway, I do all sorts of law. Number one, and there's not really a constitutional law field of practice. Uh, the Constitution affects various things, even in family law, even in civil law, even in criminal law. The Constitution affects various elements of any practice of law. And so all practices of law deal in some form or fashion with constitutional issues. Obvious ones being your substantive and your procedural due process rights, very common, rights to juries, 14th Amendment rights, rights against incrimination, etc. So only idiots like Chile think that there is some constitutional law practice. What you practice law in are cases and controversies. And cases and controversies arise in respect to contracts, torts, probate. So those are the kind of areas. So if you look at the way courts are generally set up, you've got traffic cases, you've got small claims cases. Those both generally don't have attorneys, at least in my experience in California. But then you have probate cases. Probate cases will have constitutional issues. There will be family law cases. There will be civil actions, which encompass torts. They encompass contracts. They encompass petitions for injunctive relief, things like that. But there is no constitutional law practice, really. You're taught constitutional law as its own kind of knowledge base in law school, but then each thing that you actually do in practice, like in torts, you practice. You could be a personal injury attorney. You can be a medical malpractice attorney. Those are very specific torts, and those will have you'll be educated on the specific areas of the Constitution that touch on those specific fields. So I hope that answers your questions. I practice mainly family law and civil. I do a lot of contract based law, mostly for construction litigation. Um, for other and in my own private practice, I do mostly construction based law and personal injury and family law. For other attorneys, I do pretty much whatever the fuck they hand to me. anything from probate, which I really fucking hate probate, like wills and trusts, guardianships, conservatorships, civil harassment, uh, all sorts of other business law, contract law. I mean, you name it. All right, Devin E says Leos talking to each other is usually cause to proclaim they're quote conspiring end quote in many of these videos. Probably conspiracy to do what? I don't know. Laura Rader says I don't. They had body cams. I know that in county that they were just implementing body cams in 2018, 2019. Well, there were a lot of body cams in Leon Valley. Devaney asks, was he wearing a trench coat while lurking in a darkened hallway? Probably. I mean, it sounds like it, doesn't it? Laura Rader says, Lol, I know Burns. I've lived in San Antonio and driven through Leon Valley for ages. I just find the embellishment and characterizations of the officers amusing. Burns says, I had a colonel call security forces on me because he saw me carrying 2 rifle cases and an ammo bag into a building. I was carrying 2 guitar cases in my backpack. Orange Cone says, pouring down rain, man runs a stop sign. Yep, this is why you don't talk to the police, because he necessarily ran a stop sign. Burns says, at Laura Rader, I've driven from Thousand Oaks to Lackland, 281 to 410 for over 10 years. Fun drive, lol. Captain Clown says, there are quite a few, quote, experts, end quote, who have no clue, failed law enforcement or otherwise. Yes, there are. GMK, lawyer at law, says, at Burns, do you have receipts, body cam? Continues, auditors are just fighting for freedom. And again, some of them are, some of them aren't. Laura Rader says, at Burns, I lived on Thousand Oaks for ages. Lol, you know, Morning Glen subdivision? That's where I was for over a decade. Grew up near Castroville, though. Lol, quite a drive. Burns says, at GMK, what do I need receipts for? For whatever you just purchased. Captain 3D says, why did he remove his arms? Did it hurt? Probably. You can't disarm someone if they still have arms. Orange Cone says, but sometimes it's fun to take a citation fine to be able to laugh at a cop wearing a hat condom. Okay. GMK says, the guitar incident. I'm being sarcastic. Captain Clown says, no matter how many times you tell them, Herb, they won't listen because people think they're smarter than they are and can't be told that they are until it's shown otherwise. Burns says, GMK, I didn't know for what because of my gibbering and jabbering. You continue to say at Laura Rader, now that is a drive. GMK says, at Burns, I agree, you've been jabbering, I'll need receipts. Burns says, at GMK, taking the 5th. But can you? Laura Rader pulls a squirt gun painted black on GMK. Lawyer lawn shoots a tiny stream of water in his general direction. Oh, GMK is male. Maybe. Who knows? You're free to pick your own gender. I don't care. GMK says, at Burns, fair enough. The 5th equals freedom. Devaney says, obviously a tyrant. Burns says, at GMK, zipper mouth. Laura Rader says, this story is really long and boring. I want more spice and drama to keep me awake. How many pages is this, quote, brief, end quote, anyway? 61. Bert says, year, he and him isn't being specific. That is true. Bert says, yeah. The BioExplorer says, this is like the student that I told to put her phone away during class, and she told me to stop talking to her. Difference is, student was 18. GMK says, at Laura Rader, I went away in fear that I'd be squirted a second time. I thought you'd like to be squirted. Laura Rader says, lol, 61 pages cost a pretty penny in legal fees. At least the photos take up some room. Captain Clown says, so basically the complaint was found to be unfounded. Basically, the qualified immunity was found. The court found that the cops had probable cause because they had probable cause qualified immunity. The court didn't have to consider much past that. Laura Rader says, lol, contingency basis, someone needs to rethink their calculations for winning settlements. Well, you can't win them all. That's the fun thing with contingency is sometimes you got to eat the costs if you're the attorney. You get paid a lot more if you win, but you eat a lot of costs if you lose. GMK says, I can summary this law briefing quite simply as follows. Auditors, although fighting for freedom, are quite lame. Well, that is not a true statement, as it is overbroad. Laura Cohn says, all pronouns should be banned in legal documents. I try to avoid them in my legal documents. GMK says, summarize. Laura Rader says at GMK, don't be a baby. You didn't even get wet. My squirt gun has no power. It's puny. I probably got it at a dollar store or something. You know what, Laura? Your squirt gun is good enough to satisfy. Devaney says, go away, money. GMK says, at Laura Raider, I believe you about your gun, but please, can I be a baby? Captain Clown says, that is the whole purpose of the suit. Go away, money. Laura Raider says, no king shaming here, GMK. Lawyer at law tosses a pacifier at you. Devaney says, I meant, did they get a financial statement in that case? Did they get a financial statement in that case? Did they get a financial statement in that case? I don't know what we're talking about. Laura Raider says, I always obey traffic laws in Land Valley. They love to speed truck there and get that sweet traffic fine money. I heard they put in traffic red light cameras too. Teresa Richard was very upset about the traffic cameras, the red light cameras. Devaney says, so much superfluous information. Also, there's nothing wrong with running their plate. Well, if they do it for personal reasons, if they do it for reasons unconnected with the job, then that can get them in trouble. Captain Clown says that sounds more like a confirmation. Devaney says, as a result. Captain Clown says, sounds more like there was research on a particular crime than knowing what sounds more like there was research on a particular crime than knowing what the charge was at the time. Seeing that many charges have different titles, but the elements are slightly different. Laura says, I am deaf opposed to douchebaggery. Laura Raider, oops, douchebaggery? Gasu says, howdy everyone. Laura Raider says, Michelle Berriantes Vela has also faced her own day in court because of her own misconduct, if I remember correctly, not that long ago either. Yeah, I did several videos on her. She was a real cunt. She was a real cunt. Terrible person. Terrible person who should have never been elected. Guess who says rooster? Captain Collins says, I probably need to turn my surround sound off. Captain Collins says, that is a problem. Let Inigo express himself. Devaney asks, is your rooster is peacocking? Yep. Guess who says Salvaggio was Land Valley Police Chief? That is true. Orange Cone says Merb and his barnyard friends. Guess who says who is Miller? Jack Miller, Texas Sheepdog 72? Yes. Captain Clown says, no, I would think he is more a wannabe than anything else. Captain Clown says, sometimes wannabes are more dangerous than the actual thing. Laura Raider says, no offense, Merv, but the impeachment trial of Texas AG Ken Paxton has been much more entertaining. Guess who says, oh, I never knew Jack sued Land Valley. Captain Clown says, how does one enter an actual courtroom without entering through the lobby? It's a great question. Devaney says, quite the narrative. Laura Raider says, at Captain Clown, Mission Impossible Tom Cruise style drop down from the roof ceiling comes to mind as a way into a courtroom, I mean. Guess who says yeah, can you imagine fat Jack Miller trying to do the Tom Cruise style drop down from the roof or ceiling? Can you imagine that? Oof, that would not be pretty. Guess who says he claims to be an ex-San Antonio officer or Bexar County deputy, one of those. I think it was the deputy. GMK says, who is the good guy in all this? Anderson, Miller, or Nordberg? Why does there have to be a good guy? Captain Clown says, that would be a witness statement. Yes. Laura Raider says, Bexar County, if you please. The X is silent, but it's there. Laura says, you're right. I forgot about that. Captain Clown says, laughing. Laura Raider says, lol, I do indeed. Laura Raider says, and it was guess who that bothered me? Never you. Never me? Nice. GMK says, can I pay Merv to end all of this? Yes. Pay me at my hourly rate. Orange Cone says, I lived in Bexar County for 8 years. We all pronounce it Bex-R. Orange Cone says, yes, at GMK. Use the X in the top right corner. Captain Clown says, did Rivera handle the suspected weapon? I don't believe so. Devaney says, why do you keep watching that? Laura Raider says, so much repetition in this brief. He already told us all this before. They never inspected the weapon, yada, yada, yada. GMK says, at Orange Cones, I tried all that and ended up in a live about the high price of food, so that sucks. So the Explorer says, pronouncing Gloucester, mass phonetically seems to really stir up the locals. Captain Clown says, the auditor crap is irrelevant. Salty Explorer says, yep, Gloucester hole. It says it's not Gloucester, just as Bexar isn't there. Orange Cone says, you seem challenged by technology, GMK. Okay, perhaps just go for a walk. Devin says his old pal Jack Miller. Lol. Burns says, well, I'm out. Sports time. Sports ball. Bob Boucher, you know that football's from the devil. Ed says, did the police find a rubber gun matching the description during the search? No, they did not. GMK says, at Orange Cones, can you repeat that? I fell asleep. Laura Rader says, ew, can I sue for emotional damage for having to see that partially nude in brief? Lauren Rader laughs. The Bioexplorer says, near here there is a Beaufort, Beaufort, South Carolina, and a Beaufort, North Carolina. Beaufort and Beaufort, North Carolina. Residents of both towns get worked up over how to pronounce the name. Okay. Loretta says bonus points for sure that the very easy to understand visual graphic of the raid. Yes, yes. Someone spent time to create that visual graphic of the raid. Devin says subterfuge is allowed to effect an arrest warrant. Yes, cops can lie. Captain Clown says, where is the Zhao Zhao Kung Fu action? I don't know. Orange Cone says, do not feed the trolls. They will slither away. Ed says, those cops in the enter team need to eat more. They look like sticks. Texas cops generally don't look like sticks. They all tend to be very well fed. Laura Rader says, I know, right, Ed? They must not get paid well enough to eat on a regular basis. Laura Rader covers eyes again. Ed says, Laura Rader, laughing, or smiling big, I think. Captain Clown says, evidently, Mueller doesn't recognize sarcasm. Laura Rader says, damn, Jack has quite the beer belly. Yes, he do. Guess who says, Laura, I agree. Laura Rader says, verbally, criminally trespassed. Is that a thing? Yeah, sure. You can be verbally arrested, I guess. I don't know. You can be verbally trespassed. You can be criminally trespassed. You can be verbally trespassed, then criminally trespassed. But criminally trespassed is normally where you're arrested for the crime of trespassing. I don't know. But maybe someone's using it as a verbal warning that if you trespass again, it will result in criminal trespassing charges. I'm guessing. I don't know what we're talking about. Guess who says orange cone is very true? Does a search warrant allow them to collect anything, or does it only allow for a certain list of items? Well, if they find other things that are either evidence of a crime or similar enough, like the they were allowed to take electronics, but they took the Wi-Fi unit, the modem, wireless modem, Wi-Fi router. Um, that is you're getting the arguable, but like evidence of a crime, definitely. Things that are similar enough to the stuff on the list of things that you could like. Okay, so I'm looking for a gun. Here's a gun. It doesn't look exactly like the thing, but it might be the gun. That looks kind of real. GMK says search warrant will have a scope in it. Yes, but there is some deviation allowed. And like I said, if they find like if you're looking for a gun in a drawer, a pistol in a drawer, and you open up the drawer and you find a stash of cocaine, then party. If Thunder Muffin says so, he likes big black rubber Glocks. Yes, he prefers pink dildo cocks. Orange Cone says, I had a guy reach into my open driver's side door while I was pumping gas, trying to grab my phone. He unexpectedly ran into my personal protection equipment, Rottweiler. That's why you always inspect the car before you try to steal stuff out of it. Laura Rader says, they typically don't give you pictures of the things you're supposed to search for and seize either, like the pictures of Miller at Leon Valley with his fake gun in his holster. Yeah, it's so there's some interpretation. The officers have some leeway with their interpretation of the warrant. Orange Cone says, is blah 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 a legal term? Absolutely. Captain Clown says, so when does protesting make one immune from being charged with crimes? It doesn't. Ed says, orange cones, it's a legal term of art. It is. Laura says, did Rivera never use her metal detecting wand on the fake gun? Lol. That would have provided them with a clue at the time if it was really rubber. Well, he didn't progress past. Well, I don't know. Apparently, he did not. There were no accusations of that. Guess who says GMK? Thank you. I was always curious. Bi-curious or tri-curious? The Bioexplorer says not all guns are metal these days. Johnny Switchblade says the barrels are metal. Johnny Switchblade continues the slides are metal. The frame rails are metal. Johnny Switchblade is a gunsmith, so at least my understanding is he's a gunsmith, so he probably knows. RA says at Orange Cones this is the Black's Law edition, Dictionary Merb edition, along with Oopsie Doodle and Peeky Poo. Captain Clown says there are Glocks in every color in the rainbow, as well as those that are in Microsoft's color wheel. RA says I'm already a 20-plus year TV law scholar thanks to Law and Order. Nice. St. Michael says congrats, scholars. Captain Clown says I haven't even mentioned Defense Distributed's catalog. Nice. RA says at the Salty Explorer, he keeps it on his hip, ready for any urgent needs. I'm assuming that's the pink dildo. Salty Explorer says RA exactly. JJ Thomas says Chili has his bench trial on Tuesday at 9:30. Be sure to go support him if you can. Constitutional law scholars shouldn't have to go to court or abide by laws. Captain Collin says it seems like a DeCastro move to me. JJ Thomas says question mark. Captain Collin says did Jack Miller ever Tessiact in hyperspace? Have Tessiact in hyperspace? That must be a YouTube atomic clock thing. JJ Thomas says, Captain Clown, you must know Beta Clown Chili. Captain Clown says, what the fuck? Captain Clown says, if you have seen Merb's last few videos on Chili and Floyd, Chili files motions to reconsider when his cases don't actually lay out 8 facts of the letters. That's true. Desert Sentinel says, woo, finally caught up. GMK says, a better saying is ham sandwich gives rise to probable cause. You can indict a ham sandwich. It says, but you can indict a ham and cheese sandwich? Respect earned says the complaint does show how dumb he is and the lack of any knowledge of police procedures like search warrant and execution of it, or what's covered or not under such warrant. GMK says Swiss, yes, sharp cheddar, no too sharp. Pat's Cat says I hear that grand juries do that, or do all the time. And Pat's Cat says at GMK, but I love sharp. It says, wouldn't you have to show that people who weren't activists were allowed to enter with firearms to prove that Jack was treated differently because of his activism? And covered that. It would help, but I don't think technically you would have to. Pat's Cat says thumbs up. RA says smoked Gouda for the win. Not a huge fan, but I'll eat it. Go to Friend says Obi. Do I want to be like you? Oh. Cody says Murphy's hand pink waving. Hand pink waving. Orange Coast says, what? Who got injured by Murph's privates? Logan Sandman says, hey, everybody. BioExplorer says, the few years that I worked in a law department, it was municipal law, which I liked because it covered so many kinds of law. Yeah. Orange Cone says, hiya, Logab. Logan says, cones. Victor says, chimkins. Orange Cone says, did he say Laura Cones? Captain Clown laughs. GMK says, if we don't stop commenting, will this live go on indefinitely? No. Taze Otter says, Murr was a good reader. A different Jay-Z says, former Bexar County Precinct 2 Constable Michelle Barrientos Vela on Wednesday was sentenced to 90 days in county jail and 5 years probation on 2 felony counts of tampering with records. A different Jay-Z says, yeah, I'm just catching up. Captain Clown says, sorry for being so talkative. Thanks for watching. Have a great day.